Second. All right, hold on a second, Chris. It should be live in a few minutes if this works. Okay, see if we're on YouTube now, if you can link onto it.
Sure.
I've got YouTube. You're going to hear a reco in a second. I've got it up on my screen in another tab, and it looks like it's broadcasting.
The only question is where would I find the link to click? That's sort of what I was saying earlier. Because what the IT has generally done is if you go to the PRC's website, right at the top, like as soon as you log on, there's going to be a link. So we need Miguel to put up some sort of thing that's like, hey, there was this hearing this morning, and here's the link. See what I'm saying? He's got the Carolyn's hearing from Friday, which I watched a little bit of, but we don't have a notice.
All right, Chris.
For this particular hearing. I can just email Miguel if you got other stuff to do.
Chris, can you hear me?
Yeah, I can hear you.
Okay, well, usually it's the little click here over above the I, and then there's the schedule. In this case, should be on the schedule list, and it could be there as well if I'm not mistaken. But I'm going to here. Let me see if I can chat you the link, and if you could work on that, that'd be great.
Yeah, I'll email those guys.
I suspect there's going to be some preliminary stuff going on in this hearing. There's actually been motions filed over the weekend, at least one motion filed over the weekend, believe it or not. Hold on a second. Let me get back to my Zoom. Okay. And let me send you a chat. Now I'm down to only 3 people in the waiting room. I had 5 a few minutes ago. Somebody, oh no, there they are. There's 6 in the waiting room. It's 9 o'clock. Chris, I'm going to try to do that while we're talking.
I'll take care of the IT folks. I can deal with them in the background. So I'll mute myself. All right. If you need anything, let me know.
Okay, Chris. Thanks. Check your email too. Keep your email up on a separate screen if you're not doing that.
I do. I have it open.
Okay, hold on a second. I cut and pasted the link. I'm going to send it to you now. It'll be in the subject, so you know what it is. Ryan, there you are. Okay, so that would be helpful. So, yeah. All right, thank you. Bye, Chris.
Bye.
Okay, I've just pressed the admit all button, so everybody should be lighting up. There we go, and there's the phone number, 1831, and I'll admit that. It looks like that has to be admitted separately. Let's make sure there's nobody here that shouldn't be here. It is an open hearing.
The 831 is me.
Got that. Okay, that's the only phone number. There's some familiar faces. Mr. Mauer's in the same position as last time I saw him.
Yes, sir. I'm here. Thank you.
How are you?
Well, despite all these crazy times, I'm hanging in here.
All right.
Chemotherapy and the virus don't go well together, but I can't complain. I saw the sun come up.
Mr. Bartel, you have no idea how much I understand what you're talking about. Yeah. I should talk to you privately about it. But I was diagnosed in 2009, if that means anything to you.
Well, I'm sorry to hear that. Mine was in 17. It's no fun.
Well, the recurrence diagnosis is more emotionally traumatic than the initial diagnosis. So that's kind of a crazy thing. All right, anyhow, Mr. Bartel, it's good to see you too. You got a lot of sunlight on you today.
Yeah, the lighting is a little odd today. I don't know what's going on with this camera.
Yeah, they're a mystery to us all. And I don't. Is it Chief Graham? Am I addressing you correctly, Mr. Graham?
No, I'm not a chief. Just Mr. Graham or Joaquin.
Okay, well,
Thank you.
how are you?
I'm
And
good.
I see your lawyer there in the lower left-hand corner. I normally don't talk to, I guess you would be a witness for the client. I don't talk directly to the witness. Hi, Miss Maggiore. How are you today? You can unmute. I'm trying to make sure everything's working, everybody's working, everybody can connect, and just to crank down the pressure a little bit and just talk as fellow members of the bar. Miss Maggiore, are you online?
I am, sir. Good morning.
Great. Good morning. Did we have telephone or internet issues last hearing we did together?
We had issues the one before, but I'm in my office now with an IT person within reach, just in case we have any problems.
Oh, that's great. That's great. How are you, Mr. Padilla? You're looking good today.
Well, I'm doing all right. I'm a little tired. I've been losing a lot of sleep the last week, primarily with PRC matters, but that's the nature of the profession that we're in.
You got that right. You got that right. It looks like your lighting is good today, and you've got a brand new fancy microphone there in the middle of the table.
Well, it's the same one. I'm still in my court reporter's office because, as I explained earlier, I am totally computer illiterate, so I would never figure out how to get on this thing if it was just up to me.
I don't know about that, but I notice you've brought your one-armed client with you today.
He is still here. He's just not in the picture at the moment. He can slide over if you want him to.
Well, if you don't mind, I would appreciate that. I used to be the general counsel for a state agency, and we used to have these what do they call them? They call them Polycom meetings over at closed circuit television, and everyone would try to be out of the frame of the picture generated to everybody else. Brad is laughing because he knows exactly what I'm talking about. And if you manage to be right out of the frame of the picture on these statewide meetings, it was helpful, but it was kind of wasn't so kind to the other members of the meeting. And it's good to see you, sir, there in the corner. And I'm sure we'll hear from you, but it's nice. It's better to see your face and your head than just your right arm. And that leaves Mr. Brad. I've already heard you speak, so your microphone's working and you look pretty good. How are you?
I am doing well, thank you. I'd like to inform you that Ms. Dunn says she's in the waiting room, so she could be admitted.
Okay,
at the earliest opportunity. She's going to be my witness in this case, and Mr. Montoya may join us as well.
Jason Montoya?
Correct.
Okay. All right, let me see. I don't see her in the waiting room. Hold on a second. Oh, there. I admitted all a few minutes ago.
Yeah, I just got a message that Chief Casper is also in the waiting room. So
okay, and Chris Archuleta is there already. Okay, a few people snuck into that waiting room when I wasn't looking. One thing I like to make sure is there's nobody unexpected here. This is a public meeting, I'll stress to you guys. And we are on YouTube. If someone can find us, I'm not sure how difficult it is to find us, but if they can find us, we're broadcasting around the world.
They're looking for, if you're on YouTube looking for this, bless your soul.
Well,
There's a pandemic. People are getting bored.
It's really bad.
Yeah, it is.
okay. Pandemic people, have we? Yeah, okay. Anyhow, if for the guys that just joined us, let's make sure they're working as well, because one of my objectives is to make sure everybody's got technical hookup is good. Mr. Archuleta, I see your name. Can you click off your mic and say a few words so I know you can talk? There you go.
Yes, I'm on.
All right, great. Do you have a camera that you're gonna be using?
Yes, I'm driving right now. I'm having to pick up my wife from an appointment, a doctor's appointment, and so I have the camera off so that you don't see the ceiling of my car.
Okay, well that's fine. I'm trying to make sure we all have technical hookups that are working. Miss Dunn, can you hear me? Turn off your mic.
Good morning, Mr.
Hi.
Glennon.
Do you have a camera there as well?
I do, and I will be turning it on shortly.
All right. You don't have to have it on through the whole hearing. It's not required for witnesses, but I do like it for the council. And another thing, I've been asking people to unmute. I'm going to now ask you kind of to mute unless you need to talk. Every once in a while, there'll be some kids in the background arguing or some pots clanking on the stove. I think that was in a country music song, by the way.
Don't forget about dogs barking.
The dogs barking or the cots clinking on the stove. One of those is a quote from a country music song. But they can interrupt the proceedings, and we'd rather not have that. Another thing about the hearings, I think all you guys are veterans. I think we're all veterans here. But Miss Ash Hoyman is she's the court reporter, and if two people talk at the same time, even in the courtroom, it's difficult to transcribe what both of those persons are saying. If more than two, it's even worse. On these YouTube, not YouTube, but Zoom things. Actually, one voice can cancel out the other. We actually call that Vox on radio. I don't know what it's called in the Zoom parlance. But it's important that we not all be talking at the same time. I'll try to remain as silent as possible. Okay, has everybody got their coffee on their desk? All right, Miss Allison, we're not ready to go on the record yet. I want to discuss just a few things off the record. There was a bunch of emails about the order we go in, and Mr. Borman, in the form of what I considered a query in his email, had a proposed to me order, and it's a perfectly fine order. And when I say order, I mean the sequence of the witnesses. Like in any kind of presentation at a court, I expect the plaintiff would present their case first, the movant, the person who's requesting the relief, and it just keeps it straight in my head. So I like the applicant to present their case first. That would be American Medical Response Ambulance Service, Inc., trading as AMR. But then there were some emails for people that weren't privy to this, some emails about setting the schedule, a slight variance in the schedule. So the two witnesses could be scheduled tomorrow morning, first thing in the morning, for the convenience of the witnesses. And everyone consented to that, which is wonderful. And that's the way it should be. We all need to work together, actually. It helps a lot. Without any prejudice to your client, I expect counsel to do everything they can on behalf of their clients. Don't misunderstand me there. So we're going to have tomorrow morning Miss Montoya and Miss Liba. I don't have any particular choice on which one goes first. I have read their testimony, but either one of them could go first. After, I believe Mr. Graham is going to be the first witness for AMR today. And then we're going to go straight, excuse me, I'm looking at my notes here. We're going to go, because the other AMRs will be tomorrow, and we usually do the staff last. That leaves the interveners. I don't know if there was an agreement as to which intervener is going to go first, but I propose that Superior, which would be Mr. Archuleta, go first, that Bernalillo or Albuquerque Ambulance, which would be Mr. Casper. I think he was on the line. Yeah, he's online there, Mr. Casper. And then Running Bear. And we can talk about that in a few minutes. But that would be the order today. So today it would be Graham, Archuleta, Casper, Smith, and that would be a conclusion for today. And that hopefully we'll conclude that today. It should be enough time. Now, a motion, I found a motion. Let's talk about that first. Is there any objection to we proceeding in that favor?
I just have this right to the end. I just have a question about that, because the initial round of emails I understood to be that the only witness today was going to be Mr. Graham. And I don't know how long Mr. Graham will take. I mean, he's probably going to be the longest witness, but I don't know that it's going to be all day. Then Mr. Borman got involved, and it became unclear to me because he suggested other things. So it became unclear to me, but now you're saying we're going to go beyond Mr. Graham today. Is that correct?
Yes, sir.
Okay. The other thing I have a question about, and you may be getting ready to address this. but I don't see the attorney for the fire department on here. And she filed a motion. So it is a motion that's subject to argument.
Well, let's see if there's any, if we didn't get there to the motions yet. There's two motions. There's that
I
motion.
understand. I'm just kind of, you asked if there were any
Okay.
thoughts with regard to the first part, but you didn't ask me about that, but I just thought I'd throw that in.
Okay, thank you, sir. Yeah, we've got two motions to address, preliminary motions. We're still off the record. I just want to make sure we all are on the same footing, that we're all technically here and we're on the same footing and know what we're going to do. Yeah, I want to get as much done as we can today, so we have less to do tomorrow, so we don't have to do it on Wednesday, or we're scheduled for sometime in January. That's frankly, my thinking. If it takes all day for Mr. Graham, it takes all day. But if it takes until 11 o'clock, I'm not going to shut down my computer for the day. We're gonna go forward with some more witnesses. It's set for 2 days. Yeah, that's my philosophy about it. I don't want it to be 4 o'clock tomorrow afternoon and have 3 more witnesses to go.
And
Okay. Any other comments or questions from council?
yes, Mr. Hearing Officer Fred Maurer, just a question. We all agreed, depending on how we go forward after these motions are discussed, about allowing Ms. Majori's witnesses to be called tomorrow. Now, depending on what's said tomorrow, subject to cross-examination, are you going to allow any rebuttal testimony from any of the interveners with regard to the testimony of Ms. Leyba and or Ms. Montoya?
Absolutely. Absolutely. There would be rebuttal from the direct testimony of Ms. Leyba and Ms. Dunn. And that's something else I was planning on discussing, that their testimony be in the nature of course, solely direct testimony, and of course, cross about their direct testimony, that their testimony not be rebuttal from what they've already heard from Mr. Graham, Archuleta, Casper, and Smith. So I've got a little note to myself to keep an eyeball on the nature of their testimony during the examination by the parties. Well, that was a note to myself. I'm glad you kind of brought that up. There will be rebuttal, and the nature of their testimony, their initial testimony, I mean, they could be called as rebuttal witnesses, but I can't see that happening. But their primary testimony, which is going to be starting in first thing in the morning, that's going to be the direct nature with what I call cross-examination by the other parties. Sorry, that might have been a confusing answer. Did anybody understand what I just said? Nobody did. Brad is smiling. I always get a smile out of Brad. It makes me know I'm being heard anyhow. Okay, any other questions from council? All right. Okay, so I think we should go on the, wait just one moment. I'm going to go on the record. What I'm going to do is ask everybody to introduce themselves. There's a reason, obviously, we're preserving the record. A matter of fact, much of this proceeding is from this side is making the record and preserving the record. So is everybody ready to go on the record? Anybody have anything else they'd like to discuss prior to going on the record? Nothing. Thank you, Ms. Hoyman. It's all yours. Okay, good morning, everyone. It is Monday morning. I'm Robert Lennon. I am a hearing examiner working for the New Mexico PRC. It is approximately 9:17 a.m. The date is December 14th, 2020. This is case number 20-00125-TRM before the New Mexico Public Regulation Commission. For the last 17 minutes or so, there has been an off-the-record discussion. It was no discussion of merits of the case. We simply discussed some procedural matters such as the witness order and let's see, a few technical matters of connection through microphones and speakers and video to make sure everybody was functioning and that type of thing, because we are using Zoom today. And we are broadcasting as well on YouTube. So this is a public hearing. And we are about to we are starting the hearing. What I'd like to do at this point is for counsel, for the record, to introduce themselves. After that, I wouldn't mind hearing from counsel what each of them intends to prove through the testimony and the evidence, generally the evidence that they intend to present. I find that useful when I pick up a transcript of a proceeding, which I've, of course, hadn't seen before. The first few pages can set the stage for what I'm going to be reading in the next few hundred pages. And then we will begin with some preliminary matters. There are two pending motions. There perhaps are two pending motions. There's definitely, I think, one and perhaps two. So we'll have some pending motions. Then we will have perhaps comment from the public. I doubt that there will be any. I have not received any, and I believe the procedural order indicated that I should receive that in writing. I haven't received anything, so I don't expect public comment. And then we'll go directly into the testimony. The first person to testify will be a Mr. Graham on behalf of the applicant. The applicant is the American Medical Response Ambulance Service, Inc., doing business as AMR Emerge Care. I think I said all that correctly. And they are represented by Ms. Maggiore. So I'm going to ask Ms. Maggiore to identify herself, please.
Good morning, Ann Maggiore, also known as Winnie, for American Medical Response Ambulance Service, Inc. And Your Honor, I do have a couple of preliminary matters that I would like to raise, but you just tell me when the appropriate time to raise them is.
Okay, okay. Next, Counsel for Superior.
If it may please the hearing officer, Frederick Maurer, on behalf of Superior Ambulance Service, who is an intervener in these proceedings.
Thank you, Mr. Maurer. You know, Mr. Maurer, I practiced on the East Coast for several decades, and you know, it's interesting, on the East Coast, there's much more of the formality, which I just heard in your introduction, so thank you for that. And for Albuquerque Ambulance, counsel, please.
Good morning, Randy Bartel on behalf of intervener Bernalillo County Healthcare Corporation, doing business as Albuquerque Ambulance Service.
Okay, Mr.
With me on the line is our witness, Chief Scott Casper.
Mr. Hearing Examiner, I don't know if everybody can hear Mr. Bartel clearly, but he kind of really tailed off as far as I'm concerned.
We're just going to get
to
that. Mr. Bartel, yeah, your voice was nice and strong at the beginning of your introduction, and then it just drifted off. I don't know if you moved your microphone during that time.
I could try moving.
That's much better.
A little bit here. That might help. Okay. All right. Sorry.
All right. Thank you. Counsel for Running Bear.
Good morning, Your Honor. This is Ray Padilla. I represent Rocky Mountain EMS. And for the record, with me is George Smith, who is the witness for Rocky Mountain EMS.
Okay, and for staff.
Thank you, Mr. Hearing Examiner. Bradford Borman on behalf of Transportation Division staff. I am joined by Casey Dunn, who is with the Transportation Division and will be staff's witness in this case.
Mr. Borman, for the record, the Transportation Division is part of the New Mexico Public Regulation Commission. Is that correct?
That is correct.
Okay. Did I miss anybody? I think that's everyone, all counsel and all parties. So a brief, and I do mean like a 2-minute opening statement on what you intend to prove in these proceedings and your the remedy you're seeking, if any. Ms. Maggiore, you're first.
Thank you, sir, and good morning to everybody. This hearing is to address the issue of my client's application for authority to operate in Santa Fe. I hope that it's clear that what they're seeking is interfacility transport service in Santa Fe. This would be an amendment to an existing certificate. I think that the evidence is going to show that the PRC staff has found need, not only in this case, but in the case with Helios last week. I think you'll hear testimony from AMR as to the need that exists. And I think that you'll hear testimony from Christus as to the need that they feel exists for interfacility, additional interfacility transport in the Santa Fe area.
Thank you, ma'am. Go ahead.
That was only 1 minute.
Okay.
I get two. You're going to hear from Mr. Graham. He's the AMR Regional Director. He's going to discuss the need that there is and why AMR should be the one to fill that need. Hopefully, when we address preliminary matters, you'll see that the Santa Fe Fire Department has withdrawn their motion to intervene. And we also need to have a preliminary discussion of the status of Rocky Mountain EMS as an intervener. And hopefully, at the end of the day, we'll find that there is a need and our certificate will be amended to include authority to operate interfacility transport service within the Santa Fe area. Thank you.
And thank you so much. Sorry to interrupt you. Mr. Bartel? Oh, who's got excuse me. Yeah, Mr. Bartel, ABQ Ambulance.
Good morning. May it please the hearing examiner. The evidence of need is not present in this case. The statute is clear that there must be a showing of need that the incumbent providers are unable to meet. And that evidence is completely lacking in this case. What we have is apparently a single customer prompting this application, which has chosen not to access all of the available services currently authorized in Santa Fe County. So this application and the evidence that's been presented by means of the pre-file testimony does not meet the statutory requirements of showing that there is an unmet public need that the incumbent providers are incapable of meeting and that their service is currently inadequate. So we expect to ask that this application be denied for those reasons.
Thank you, Counsel. Mr. Maurer, please.
May it please the hearing officer, members who are participating today, Fred Maurer on behalf of Superior. I join with Mr. Bartel. As the hearing officer and the parties know that these proceedings are controlled by statutory requirements. Part of the statutory requirements in this case deal directly with the question of whether or not existing carriers in the area impacted by the application have not been able or unwilling to provide the transportation services being sought by the applicant. In this particular case, Mr. Bartel is right. We are only aware of one party who is claiming that there may be a need for additional service in the Santa Fe area for interfacility transportation services. It is Superior's position that, as stated, there is absolutely no proof in this record that Superior has been contacted and refused or was unable to provide the requested services. What the record does show through the testimony of Mr. Archuleta is that Superior is ready, willing, and able to provide additional ambulance services in the Santa Fe area to meet the supposed need of St. Vincent's with regard to interfacility transportation services, and further that Superior has never been contacted by St. Vincent's and requested to step up and fill this need. Thank you.
Thank you, sir. And Mr. Padilla?
Your Honor, Rocky Mountain EMS intends to prove essentially what is in the pre-filed written testimony of George Smith. Rocky Mountain agrees
with both Mr. Bartel on behalf of Albuquerque Ambulance Service and with Mr. Maurer on behalf of Superior Ambulance, that the application and the testimony that's going to be provided here does not establish the need for another ambulance service in Santa Fe County, as is been made clear by the pleadings. Also, and although this doesn't have anything necessarily directly to do with this, you're the same hearing examiner on another application, which is the application of Helios. And so there's two competing applications here, and I'm not quite sure how you're going to deal with that. And I don't intend to present evidence with regard to that. But we're ultimately going to be asking that the application be denied. We have an unusual circumstance, as you're aware of, and is going to be argued with regard to a motion to revoke our status as an intervener, probably in a few moments. And then there's another motion. There was a reference to Santa Fe Fire Department having withdrawn its status as an intervener. They did not withdraw. They filed a motion, and I think it's necessary to argue that motion. And I won't get into that at this point, but I think we've got an actual motion that has to be argued.
Thank you, sir. Mr. Borman, please.
Thank you, Mr. Hearing Examiner. I'll be really brief. Staff's testimony basically takes a position that AMR has complied with the requirements in its application. Staff has identified a growing need for ambulance service in the Santa Fe area and recognizes the value of another participant in the provision of ambulance services statewide and in the Santa Fe area.
Thank you, Mr. Borman. That was succinct. And I think that's everyone. A few words from me. I see each case as each case. I see the parties having burdens of proof and separate remedies requested. I make my recommendation based on the evidence in the case. I don't make my recommendation based upon evidence in another case. And I certainly don't make my recommendation about evidence in another case I didn't hear. And I don't make my recommendation on what I may have heard somewhere outside of the hearing room, for example, even the Zoom hearing room. So this case will be decided on the evidence in this case. Whatever happened, the name Helios was mentioned twice. That's a case that I have heard. And this case won't be decided on what was heard on the evidence in the Helios case. And there was mention of a case involving Running Bear, Rocky Mountain last week. I'm aware of that case. This case will not be decided on what happened in that Rocky Mountain case. I think it was on Friday. And I understand there's a motion which relates to it. We're going to get to that. We haven't got there yet. But the evidence in this case is the evidence in this case, and the evidence in the Rocky Mountain case from last Friday is not the evidence in this case. Anyhow, that's how I see it. Is there any questions about what I've just said before we move on to the two preliminary motions? No, I don't think so. Okay, let's do perhaps the easy one first. Mr. Padilla's, I believe, made it clear, and he's probably going to say it again, but he apparently opposes the city of Santa Fe's motion to withdraw as an intervener. They are not online as far as I know right now. Let me check my waiting room, make sure nobody's in the waiting room. Let's see here. I don't have a waiting room listed in my participant list. So no one's in the waiting room. Council for Santa Fe is not here. They filed a motion to withdraw as interveners. There are obviously a few interveners, so the case will go forward. They're not the sole intervener. Let me take more or less a poll if there's any objection, first of all, to the motion to withdraw. It looks like it was filed on December 11th, which was just last week. Ms. Maggiore, we'll start with you. You have any objection to Santa Fe's motion to withdraw as an intervener? Can't hear you.
There we go. AMR and the city have entered into a settlement agreement. We do not oppose their motion to withdraw.
Thank you. Let's go to Mr. Maurer. Any objection?
Mr. Hearing Officer, Fred Maurer on behalf of Superior, the only part of the motion that I object to is paragraph 3. I ask that comment by the city, especially since they don't have a representative here today to answer any questions concerning that statement, be stricken from the motion.
I'm not, thank you. Is any comment? Well, we'll get to that in a moment. I appreciate you wanted paragraph 3, which states the city agrees that there's currently a public demand for additional interfacility ambulance transport. I might as well comment before other councils comment. I don't consider paragraph 3 evidence in no way, shape, or form, and I can't use it in any way, shape, or form in making the determination. In my opinion, these are simply averments supporting the relief requested in the motion, and the relief requested is to withdraw as interveners, and so these are simply averments, not evidence. I don't believe I can rely, and I will not rely upon averments in a pleading as evidence in a case. So it's going to be less than prejudicial. Ms. Maggiore, since you've already talked, do you have any comment? I'll go to the other guys, but do you have any comment about paragraph 3 and Mr. Maurer's statement?
Well, I'd like it to stay in, Your Honor. It's in the record, and I think it's important to note that the city does feel that there's a need, and the reason they feel that way is that, they're having to pick up some of the slack when there is a dearth of carriers to meet the need, and I think that's where that paragraph comes from.
Do you contend that that Ms. Salazar, counsel for the city, the assistant city's attorney's averment is evidence?
I think it's in the record, and I'd like to have it considered as evidence.
Fine. I understand your position. Mr. Maurer, excuse me, Mr. Bartel?
Thank you. I have a concern about paragraph 3 as well, because
Let's talk about whether you have an objection. Do you have an objection to
I have an objection. I have an objection to the motion to intervene on both that ground and the ambiguity that's now introduced by paragraph 2, where it says that there's a deal between the city and AMR, which is not attached to the motion. And so I think that the question of what the remaining scope of service is that the city fire department will continue to provide with respect to interfacility transports is now unclear.
Thank you. Does anybody have any argument concerning the status of an intervener when the intervener fails to appear for the merits hearing? And since you're still up, Mr. Bartel, you have any opinion about that?
Well, I think that the intervener may in fact waive its right to present evidence. But what we've got now is a last minute motion to withdraw, which creates a problem. So it seems to me that this needs to be fully determined before the motion can be granted.
Thank you, Mr. Bartel. Mr. Padilla, from what you said earlier, I understand you're going to also object to the motion to withdraw as an intervener. What's your position, sir?
Well, I strenuously object to, first of all, the late filing of the motion. It was sent to me by email dated December 11, 2020. That's last Friday. It was sent at 4:11 p.m., less than an hour before close of business. And we're here on Monday, the next particular business day. So I object on the basis that there is not ample opportunity for myself and probably for the other parties to properly explore this particular motion and to deal with the motion. I agree with the comments that have been made by Mr. Maurer and Mr. Bartel. I have a particular concern with paragraph 1, where it is stated that there's been a settlement agreement entered into. Mr. Bartel has pointed out that the settlement agreement does not accompany the motion. As far as the intervener not appearing with regard to the motion, that creates other problems for me, because in an email which the hearing examiner sent, it was an email to Ms. Maggiore that was actually sent last Friday as well. There was some confusion about some things that were occurring with regard to parties' witnesses. And the hearing examiner's email says, broadly, a witness is not a, quote, party's witness, close quote. The testimony of a witness, when admitted, may be in whole or in part favorable to the cause or one or more of the parties. Those parties may consider a witness presenting favorable evidence, quote, their, close quote, witnesses. Obviously, that's why they, quote, call, close quote, or file the direct testimony of the witness, and then you go on to explain. My concern is, if you look at the direct testimony that was filed on behalf of the city of Santa Fe supporting its burden of proof, this direct testimony was filed on September 10th of 2020. That direct testimony in numerous places supports the position that there is no need for additional service in Santa Fe. Now apparently, at a very, very late stage in the game here, or in this proceeding, I shouldn't call it a game, in this proceeding, all of a sudden that position is going to be changed. And part of the concern that I have at this point in time is I believe that this direct testimony, which was filed by, it was verified by Michael Suber, who is Deputy Chief and Medical Officer for the City of Santa Fe Fire Department. And I believe it has to be admitted into evidence. How do you admit that into evidence without Mr. Suber adopting it on the record? How do you cross-examine Mr. Suber without Mr. Suber actually being here? Perhaps there was another method of doing this, and I'm not sure whether the PRC allows it, but it would be a different argument if the city of Santa Fe had simply filed a withdrawal of its status as an intervener. They didn't do that. They filed a motion. It's entitled the City of Santa Fe's motion to withdraw as an intervener. That to me means, and this is an absolute, that means that the city was required this morning to be present to argue this motion and to convince the examiner that this motion should be granted. And without the city being here, I don't think that the hearing examiner has an adequate basis for making a ruling. So I think it's necessary that somebody get the attorney for the city of Santa Fe to participate in this matter. And I guess that would be Andrea Salazar, who signed this particular motion. But the motion is extremely prejudicial, not only to the situation involving Rocky Mountain EMS, but I would argue that it's prejudicial to the situation involving the other parties, because this written testimony clearly supports the position that both Mr. Maurer and Mr. Bartel have expressed, and that there's a lack of need for additional service in Santa Fe for different reasons, but clearly that there's a lack of need. And that testimony on behalf of the city of Santa Fe at two different places specifically says that Rocky Mountain and Superior are in fact supporting the need and and taking care of the need when the city of Santa Fe is unable to take care of the need. So we strenuously object. And again, I suggest, this is up to you, of course, but I don't see how this can be decided without hearing from the city of Santa Fe. And I don't know how, even if the motion is granted, the hearing examiner can make a determination, or what determination the hearing examiner would make as to now either myself or Mr. Bartel or Mr. Maurer, or perhaps all three of us, wanting Mr. Suber to be our witness, as is indicated is appropriate in the email that I quoted from.
Thank you, Mr. Padilla. What I did when I listened to what you just said is divide your statement into two columns. One column is legal argument, which I invited, and the other column is what I consider testimony. And you're not sworn in as a witness, and you're not a witness. So I obviously will discard anything which rang as in a bell ringing, rang as testimony. Mr. Borman, do you have anything you'd like to argue?
Yeah, I'll try to be brief here. First of all, we have this motion which discusses a settlement agreement between AMR and the city. As Mr. Bartel raised, we don't really know what's in that settlement agreement. I think it would be in the public interest if the commission or if the hearing examiner were to grant this motion to at least know what's in that settlement agreement, to have a copy of that in the record. Now, that said, I mean, I kind of think we're arguing about things that really don't have much practical impact one way or the other. The fact of the matter is, if the commission grants or the hearing examiner grants this motion, then the city is out of this case, and they don't cross-examine witnesses, and they don't put forth their own witness. Well, the city's not here, and so if the hearing examiner denies the motion, we're pretty much in the same spot. So, I mean, they don't have to put forth their witness. If they were forced to put forth their witness, they could ask them a question. Do the answers in your direct testimony as you set forth, are they still true today? And the answer would be no. So, I mean, I guess we're really arguing about something that I don't see has a real practical effect. I mean, the city wants out. I think it's in the public interest to know and to understand why it wants out. But beyond that, I don't know that there's any practical way that we could force them to participate.
Thank you, Mr. Borman. You didn't know it, but I scribble notes down while people talk. And before we got to you, I had scribbled down, can't push a chain, and not over till it's over, and encourage resolution by settlement. And they haven't not appeared until the case is over. So those are all my scribbles, and let me illuminate a little further on them. I generally encourage resolution by any means other than litigation. So it's frankly a good thing typically that we can resolve at least part of a case without litigating that part of a case. It seems like one of the parties has resolved at least their reason for being here. That would be the city of Santa Fe. So I am not inclined to discourage a resolution outside of litigation. Secondly, like I said, I put down, you can't push a chain, and it is not my place to be calling Miss Salazar on the phone and bringing her into this hearing. If she or her party doesn't want to be here, they're not going to be here. Next thing I wrote down, it's not over till it's over. And, this hearing is expected to go 2 days. If she appears, or the city appears later today, or tomorrow morning, or even tomorrow afternoon, before we conclude and adjourn this hearing finally, she's appeared. She'll be late, but she has appeared. So I'm not inclined to dismiss her motion for failure to appear and argue her motion yet, even though normally I would do this as a preliminary motion, and normally we would do it preliminarily. Next thing, I believe we can go forward and have the remaining evidentiary hearing, which we have all anticipated, without me ruling on this motion at this time. So I'm going to decline to rule on it preliminarily. And I'm hoping I'm going to remember tomorrow afternoon to rule upon it. If anybody sees that I'm forgotten it when I'm about to adjourn the hearing, please let me know, and I will then rule upon this motion. But until then, counsel for the city hasn't failed to appear. They're just late. And that's the way I see that. And I don't see a prejudice yet because we haven't gone forward. There hasn't been a motion to move the admission of the pre-filed direct testimony of the city. I guess one of you guys could move to admit it if you think it's that helpful to your case. I don't know how you're going to do that unless you had subpoenaed or got that witness to appear on your behalf. I suppose you could do that too. It would be unusual in these types of proceedings, but I can imagine other types of legal proceedings where such a thing does happen. I've personally participated in many criminal actions where uncooperative witnesses were brought into a courtroom to testify. This isn't that situation, but in my mind, I'm analogizing it somewhat to that because you all could call this witness if you choose to do so, and you chose to have his pre-filed testimony admitted. Otherwise, it's not going to be admitted, and otherwise the city is going to suffer the consequences, if any, of failing to appear for the hearing. And I do stress, if any. So at this point, I'm going to defer on a ruling on the city of Santa Fe's motion to withdraw as intervener. And before you guys say anything, let me make my phone more quiet here. Thank you. All right, so that motion has been ruled upon, and now we can move on to the second motion.
Mr. Hearing Examiner, may I just be heard on this?
Well, I've already
There is
ruled on it, so
prejudice.
it's not going to change the ruling, but, you know, I'm not going to.
I understand that you're not going to rule right now, but there's prejudice in the parties not knowing what the settlement agreement is. The City of Santa Fe Fire Department's testimony says that it is an integral and major participant in interfacility transports in Santa Fe County. Now they're gone without any explanation of what happens to their call volume. I mean, they claim that they've been handling the majority of it for the sponsor of this application, Christus St. Vincent. And so I believe we need to see that settlement agreement. And I don't care whether it comes from AMR or it comes from the city, but I don't think that it is fair to the parties who have appeared here to try to proceed on the last, 11th hour withdrawal of a major participant in the system. The commission's duty here is to protect the citizens of Santa Fe County, and it can only do that if the entire system and all of its participants are present. Now one doesn't want to be here, but there must be a settlement agreement that explains why and what's going to happen with respect to how the fire department is going to handle the call volume. So I think at a minimum, we need to see that before we can proceed with testimony in this case.
Thank you. I'd be willing to comment. Cases are settled at the 11th hour, 59th minute on a regular basis. What you've implied, if not expressly stated, is that you want to conduct discovery, which is an implication that you want to postpone this matter so that you can conduct that discovery. Is that what you're? Am I hearing you correctly? Be more clear if that's what you're asking for, please.
Yes, I think that discovery would be appropriate, and the possibility of subpoenaing the city's witness to appear involuntarily, as you say, sometimes hostile witnesses must be subpoenaed to appear at a proceeding. I think that we need to have that opportunity. Unless we can have the information presented voluntarily.
Are you moving for a postponement to conduct discovery?
I think that's going to be necessary.
And Mr. Hearing Examiner Fred Mauer, on behalf of Superior, I would join with Mr. Borman. I think this information needs to be disclosed. And I would join with Mr. Bartel that there is a creation of prejudice in this record now if this is allowed to continue with this information concerning what's happened not disclosed in the record, thereby preventing us as interveners in being able to rebut what's happened. Thank you.
Mr. Hearing Examiner, this is Ray Padilla. I
Yes, sir.
also join in the motion, and I would add to what Mr. Bartel and Mr. Mauer have said is that you have suggested that if one of the parties wanted to bring this witness before you for this particular hearing, that we have the opportunity to subpoena. The way I understand the rules, we have to file a motion and get your approval for a subpoena. You have to issue a subpoena. And I can tell you that in another case I had with another hearing examiner, when I requested a subpoena, the subpoenas were issued, but for some reason or other, that particular hearing examiner took the position that it was necessary for the commission to actually issue the subpoena, not the hearing examiner. And I'm not suggesting that you don't have the authority to issue it. What I'm trying to point out is that filing of a motion to issue a subpoena is one thing, but then having the subpoena served, having the possibility that somebody's going to move to quash that subpoena, which I think can be anticipated at this point in time, and having to litigate the subpoena and the discovery process and everything else that we're talking about in this point in time is not only extremely prejudicial, but causes problems with this procedure moving forward in an appropriate manner. And I would point out in that regard that while I would anticipate that Ms. Maggiore might argue that her client wants this thing decided, and I can understand that, the evidence on the part of Ms. Maggiore clearly suggests that the decision to go down this route was made many, many months before the actual application was filed. So if the applicant waited many, many months before filing the application, I don't think they could argue very strenuously against postponing this to allow this matter to be resolved so that we can proceed smoothly and carefully and get everything before you in an appropriate manner.
Thank you. And sir, you may be wrong, but I don't believe I mentioned the word subpoena. It's possible. I probably said you can bring this witness in. And as a rule, I don't ask questions unless I know the answers, and I don't call witnesses unless I know what they're going to say. So I meant to bring him in as voluntarily. I didn't mean to subpoena him in. However, as you brought up, as I believe you brought up, subpoenas may be available if you want to subpoena a person. And it's been my experience that a person who appears solely because they're subpoenaed to be present is less than the witness you may want. That's just my sidebar there, if you will. But my point is, I don't remember me mentioning the word subpoena, and I think you said that I did.
Yes,
so
sir.
Anyhow,
just to be clear, sir, what I was referring to is, and I was taking notes. You said that no motion to move pre-filed testimony of the city had been made, and that any one of us could do that. And then you commented and you said, how do we do that unless we subpoena the witness? That's where I got the word subpoena from.
Thank you, sir. Mr. Borman, do you have a comment on the motion to postpone to conduct discovery made by Mr. Bartel?
I would oppose that motion. I think this has actually become kind of ridiculous. I mean, these parties are arguing that they have a vested interest in testimony that they're hoping another party doesn't even want to put forth. I mean, I've been doing this 30 years. I haven't seen that sort of thing before. And so it's, there's no reason to delay this. The parties are, in charge of their own testimony. They can put forth their own testimony that supports their own case or that refutes AMR's case, and that's fine. And that testimony will be considered by the hearing examiner. That they all of a sudden feel that they need the testimony of the city of Santa Fe. I've never even seen anything like that. Now, I do think that it's in the public interest to have a copy of that settlement agreement in the record, not for the benefit of the parties, because I don't think it really makes a difference to the parties. I think it's for the benefit of the commission in understanding, why it should approve or not approve this case, this application.
Thank you.
I don't know that it needs to happen today, that settlement agreement get in the record today in order for us to proceed. But I do think it should be made a part of the record.
Thank you. Ms. Maggiore, I presume you oppose a motion to postpone to conduct discovery. Is that correct? Can't hear you.
How about now?
Yeah, there you are. Okay.
Okay. We initially sent our application to the commission almost a year ago. This has been dragging on for an abnormally long period of time. Some of it COVID related, some of it not. But we are very anxious, particularly in light of recent events, to get this heard. And I'd like to try and make it easier for everybody, because this is really just a thinly veiled attempt for the interveners who are present to try to postpone what almost seems like the inevitable at this point, that this hearing is going to take place. I will describe for you what's in the settlement agreement, and I don't disagree with Mr. Borman. We'll go ahead and provide the settlement agreement on the condition that this hearing is not postponed past tomorrow. We need to get this done. I don't want to drag this out another 6 months with some excuse about we need discovery. Let me explain to the parties what the settlement agreement is about. What the fire department...
Mr. Hearing Examiner, I'm going to object.
You're interrupting me, Mr. Bartell.
You are presenting
interrupting
evidence
me.
now.
You
I
are
want the
interrupting me.
evidence.
You are interrupting me. I'm making an offer of proof. You are interrupting
You
me,
haven't
and that
offered
is...
us the proof.
Mr. Bartell, please let her finish, and then I'll give you a chance to talk. Please. Ms. Maggiore, also, I just wanted to get your stance. You obviously object. I didn't want you to offer a resolution in a way, and let me cut you off, Ms. Maggiore, with respectfully. That's frankly what I was thinking. I always think it's a great thing when members of the bar can talk with each other and respect each other and realize that we're all in the same boat. We're all trying to work and protect our client and further the interest of our client, but the lawyers should be working together. And what I was thinking, in this day of technology, I could very simply just adjourn, or not adjourn, but we could put this hearing on hold for an hour. And during that hour, there could be a conference with counsel by the telephone or by Zoom. And you could simply describe, one alternative is to simply describe what's in the settlement agreement, which you were about to do, I believe, or you could simply fax or even use the Zoom system to transmit a copy of the written document if there's a written document. I don't know that there is. So there's ways of resolving this so we can go forward. I will disclose to all of you, my objective is to move the case forward, not because I have any favoritism toward any party, and not to the applicant or Ms. Maggiore. It's just that I don't need my cases backed up. And I think it's my duty as a public servant working for the commission to keep things moving along. So I haven't ruled on the motion to yet, but I will let Ms. Maggiore finish, and I don't want her, and then we'll hear from Mr. Bartell because he had something to say. Then I'll poll the rest of the party, see if they have anything new to say. I don't need new argument. And then we'll roll on what I had to drag out of Mr. Bartell as a motion because he implied it, but didn't seem to want to say it straight. Then we'll take it from there. I'm sorry, Mr. Bartell, that didn't mean to be offensive there. But I didn't hear the word motion to postpone. without me prodding you a little bit. So first, let's let Ms. Maggiore finish, please.
All right, the one thing that we do not want here today is further postponement of resolution of our application. It's gone on close to a year, and it needs to be resolved today. We need to get this moving. We need to get it finished. I think that's in everybody's best interest, particularly in the best interest of the public.
Thank you.
I don't have an objection to what you propose. I would be happy to make an offer of proof at this time. It's really nothing sinister. It's nothing that I think should impact anything that happens here today, one way or the other. But I feel at this point that I really do have to bring up the issue of Rocky Mountain's participation as an intervener at this point, because of what happened on Friday.
We didn't get to that yet.
That effect.
We didn't get to that motion yet.
No, I understand that,
That's
but if
another
you're
motion.
asking us to go into conference
Mr.
and
Hearing Examiner, I hesitate to interrupt, but I have to object to any comment on that at this point in time.
Okay, identify yourself for the record, sir.
Ray Padilla.
Thank you.
okay, again, I'm being interrupted.
Yeah, you're right. You're absolutely right. So did you have anything more to add, Ms. Maggiore?
Well, I was trying to, but it seems that people feel free to interrupt, which is not
Okay.
appropriate procedure.
Well, you might have picked up when that happens. I try to settle things down just a little bit. And I really believe we're all members of the bar and we're going to see each other again and again. And we're all just trying to do our job on behalf of our client the best as we can. And we might not like each other's clients, and our clients might not like the other lawyers' clients, but that's really no reason for the lawyers to not like each other. I like most of the opposing lawyers who sat at the other trial table when I used to try cases, even though our clients didn't like each other. So you don't have to like each other, but it doesn't hurt. And Mr. Bartel is just trying to represent his client the best he can, and I understand that, and that's fine. And Mr. Padilla is trying to do the same thing to represent his client the best he can, as are you, Ms. Maggiore. We're all trying to do the best we can on behalf of our clients. There's zealous advocacy is respected and very respected by me. I do my best when I was advocating to be a zealous advocate. But the objective is typically to get or prevent the relief requested. And there's a line over which the zealous advocacy changes from zealous advocacy into something else. And it's counterproductive. Short term, sometimes, and very often on a long-term basis. So I ask you guys to just keep that in mind. What I do doing these hearings, I'm of course a hearing examiner, but sometimes I feel like a traffic cop. And yeah, that was a joke. Thank you. That I got a smile. Yeah, I feel like a traffic cop. And what I mean by that is I want to preserve the record so that there are no grounds for appeal. So that no party is prejudiced because I didn't allow that party's lawyer to provide input when that party's lawyer wanted to provide input. So what I'm trying to say is, counsel, please don't interrupt each other. If you've got something to say, I will give you the opportunity to say something. All right, so let's go forward. Ms. Maggiore, I think you were finished talking, right?
No, I wasn't finished talking.
Well, I just wanted to hear argument on the motion to postpone, and that sounded like some pretty good argument against the motion to postpone. But if you've got something else to say about the motion to postpone, go ahead.
Yes, I agree with Mr. Borman that we should not postpone this further. And I would be happy to outline the provisions of the settlement agreement. On one hand, as a tort litigator most of my career, the settlement agreements are confidential as a rule. This one involves a government agency. And frankly, I've checked with my client and we don't have a problem with adding that settlement agreement into the record for completeness. I think it will explain and I am willing to explain sort of what the provisions of it are and why it took the path that it did. And I want to assure everybody that negotiations have been ongoing since the city intervened. And we have been talking with them, as we are encouraged to do with all of the parties, to find out what their issues were and to try to resolve them short of being part of this hearing. And I think we were successful in doing that. And now, because we're successful in doing that, everybody's going to get hysterical and say that now we have to postpone the hearing and we have to have discovery and we have to do all these other things. I don't think that's the way this is supposed to work. When you reach a settlement agreement with another party, the other parties don't get to do discovery into that. I don't see any rule of procedure that would allow for that. And if somebody else sees one, please point it out to me, because I don't see it. What this is an attempt to derail this hearing, and to derail it because we did the right thing and reached a settlement agreement. Now I'm finished. Thank you. And I appreciate your support in lawyers not interrupting one another.
Thank you, ma'am. Mr. Bartel, I remember you had something to add. Please do.
Thank you. I do have something to add. The problem here is that this is not tort litigation. This is not a bilateral situation. The commission is in the position of having to govern a transportation system. The city is an integral part of this system. So it is inappropriate for the city to simply no longer be a participant in a case which requires that there be evidence about the functioning of the entire system. So if AMR will make the settlement agreement available, I think that'd be very helpful. And I suggest that, in fact, it may be appropriate to require the city to appear to testify about how it intends to go forward, whether or not AMR is a participant in the system or not, because it affects all of us. I mean, none of the interveners can effectively know what the quote unquote unmet public need is unless we know what the city is doing and it will continue to do in the local system. That's my concern.
Thank you, Mr. Bartel. Any other council have any comments?
I just want to say one thing in response to Mr. Bartel,
Please.
and that is that the city didn't have to intervene in the first place. Okay, they could have just stayed out of it, and there was no way you can force them to be a part of this. They chose to intervene. We resolved the issues that they had, and I'd like us all to be able to move on.
Thank you. Mr. Maurer, you had something to say? I saw you raised you entered the frame of my screen here.
Yes, sir. I agree with Mr. Bartel. I understand what Ms. Maggiore is arguing, but that's not taking into consideration they did intervene and they took a position with direct evidence testified to that there was no need for additional carriage. That needs to be addressed, and the city needs to present this and explain what is going on and what the city has agreed to. That is only fair for the interveners. Thank you.
Thank you. And Mr. Padilla, did you have anything to add, sir?
I agree with Mr. Bartel. I agree with Mr. Maurer, and I would specifically once again point out that what we're dealing with is we're dealing truly with an 11th hour situation here. When a motion is mailed after 4 p.m. on a Friday and the hearing is supposed to take place starting at 9 a.m. on a Monday, and there's not even time under the rules allow time to respond to a motion, which goes far beyond that. I think the rules are 12 days to respond. I think that creates a prejudicial situation, which has to be dealt with appropriately. And particularly with regard to what Mr. Maurer said, that there needs to be an explanation as to why the city initially said there's no need, and then all of a sudden they're saying there is in fact a need. We don't know what happened during these negotiations. We don't know what promises were made between the parties, particularly promises on the part of AMR. And not knowing these and not fully litigating these is extremely prejudicial to Rocky Mountain, and I think it's prejudicial to Albuquerque Ambulance and Superior as well.
Thank you, sir. Ms. Maggiore, is there a writing documenting the agreement?
There is, sir.
Okay. All right. Well,
Mr. Lennon, if I may be heard, this is Brad Borman.
so sorry, Mr. Borman. I guess I did forget about you, even though you're right there. Please.
Not a problem, and I'm going to be very brief.
Yes, sir.
You might want to look at the case last year that the commission had. It was docket number 19-00018 UT regarding the PNM's abandonment of San Juan. And what happened with one of the parties, I believe it was the Albuquerque-Bernalillo County Water Utility Authority, was a party, and then they decided to withdraw as a party after submitting evidence and participating in the hearing and even in the briefing. So I just was going to point that to you as potential precedents to look at.
Is that in the final order? What you're describing?
It wouldn't be in no, you'd have to look through the record to see exactly how that played out.
Well, that could take me a little time for sure. But it's well taken. Do you have any other comments, Mr. Borman?
That's all I have to say.
Okay, well, let me say a few things. What we have is a motion. Like I said, you can't point a chain. If they don't want to be here, they're not going to be here. They want to withdraw their motion to withdraw their intervention. The underlying basis for the reason is because of the settlement. So the settlement and the withdrawal of intervention are really two animals that are happening simultaneously. Normally when there's a settlement in a case, well, let's say a case with two parties. Well, obviously each of the two parties knows what they settled because there's a meeting of the minds, by definition, a settlement. When there's multiple parties, there isn't a settlement unless all the parties participate. So my position is that we've been going now for about an hour and 14 minutes, and I like to take a break every hour and about 5 minutes so we can use the men's room. I'm going to suggest that we take a break for an entire hour and that we reconvene at 11:15. Now, during that 1 hour, we're not going to be sitting around. We're going to be working. We're going to go off the record, and I'm going to ask Ms. Maggiore to circulate to all parties. Email is the way we do it these days. So if she could scan it and send a attachment email of the settlement agreement to all parties. And frankly, I would ask that the parties talk to each other. Now, the major opponents, Mr. Bartel and Mr. Padilla and Ms. Maggiore in particular, I would ask that you guys talk with each other upon receipt of the settlement agreement and see if you can agree to proceeding and going forward today, now that you have it in your hand. That's what I'm suggesting that we do, and that is what we're going to do. Are there any questions?
Yes, sir.
Ma'am.
I offered to produce a settlement agreement with the understanding that this hearing was going to proceed today. I can tell you what's going to happen if we do what you just described. They're going to look at the settlement agreement and they're going to go, oh, we have to have discovery. We didn't know about this. We didn't know about that. And it's going to derail this hearing, which is exactly what we don't want. We're participating in good faith. I am willing to produce that settlement agreement, but not if it's going to cause a delay in these proceedings. I don't think discovery into a settlement agreement is the way things usually proceed in these hearings. Often parties reach settlements that, had that motion been titled notice of withdrawal, that would have been the end of it. And I'm sorry it didn't come out that way, but I didn't draft it. But we do not want to create a situation where these proceedings are delayed. That's prejudicial to us. And the other interveners here are looking for a way to do it. The second thing I want to say is that I object to Mr. Padilla even being a part of these discussions because of what happened on Friday. That's the elephant in the room here, is that they're still sitting at the table while meeting none of the statutory and regulatory requirements for being an intervener. And they're the ones that are raising a big stink about this. They shouldn't be a part of these deliberations. And I think we need to hear that motion before we go a whole lot further.
I appreciate your zealous advocacy. I'm not comfortable being leveraged into a decision, so to speak, and I'm still going to ask to do what I just had asked you to do. So we're going to take a break for an hour until 11:18, and by that time, I hope the settlement agreement we've been referred to has been circulated. At that point, I'm going to rule on the motion to postpone, and that's how we're going to proceed. Thank you. See you all. Yes, sir.
Just Ray Padilla. I'm not in my office, so if Ms. Maggiore is going to email me something to my email, I can't print it out because I'm not there. So I'm going to have to get the email address for the place where I'm at if she's going to email this. But Ms. Maggiore says I shouldn't even be here, so I don't know if she's even going to be willing to email it to me. It's my understanding you're ordering her to do that. But just from a practical standpoint, she's got to email it to me where I'm at. And second, are we going to stay on this Zoom to have this discussion, or how are we going to handle that practically speaking?
The Zoom is going to continue to run. The YouTube is going to continue to run. Miss Hoyman is going to stop the record, and we're going to go off the record at that point. And Mr. Padilla, give her the benefit of the doubt. She's a zealous advocate, but I'm sure she's going to cooperate. So let's give her the benefit of the doubt by all means. Is there anybody at your office, Mr. Padilla?
No, sir. I'm a sole practitioner and I do not have a secretary.
All right. Well, you're at a court reporter's office, and I presume that they have a fax machine. I don't
know if they have a fax machine. I know they have an email, so I can
don't think they'll mind
you. Excuse me?
Announce it right now. What's their email address?
I don't know. I have to go ask.
Okay.
It's not my email. If you give me just a moment, I'll go ask them.
Go do it right now. We'll wait for you.
Thank you, sir.
I don't want to say anything without Mr. Padilla present, so that's all I'm going to say.
Mr. Hearing Examiner?
Yes, sir.
That email address is office@Williams, WILLIAMS, NM, as in New Mexico.com.
Thank you, sir. Okay, so we're going to go off the record for an hour. It's now 10:21 on my computer. We will go back on the record at 11:21. We've all got some homework to do, including myself. Ms. Hoyman, we're off the record now. Thank you all. No, please.
Examiner, can you tell us, should our meeting occur off this Zoom conference?
Exactly.
Okay, so we should.
You should exchange the information we've discussed, the settlement documentation, and I think it wouldn't hurt if the council have a discussion among council.
As in a phone conference?
Yes, ma'am.
Okay, I can open up a conference line here at my office if.
That'd be great. I don't need to be party to that, and I don't think I should, and I don't want to be. But, you know, a couple of feathers seem to have been ruffled. And if we want to move this case forward, and I know you do, it doesn't help to ruffle the feathers. So maybe we can unruffle them just a little bit and move forward as colleagues.
Okay,
Right.
if we can stay on for just 1 minute, I'll get the number for the conference line for my office so that everybody can have it.
Nice. Mr. Borman, I'm going to be trying to find what you were referring to in that case. That was
It's
the San
a,
Juan generating case. I mean, that's
yeah, it is a
substantial.
very long record.
I was going to
It's a-
say, I don't know that I'm going to find it, but
You
I'll
may
look.
not. You may be able to refer to others to help you find it, but there's, well,
All right, here we go. 1-800-747-5150. And then you'll need to put in an access code 690-9737.
Wonderful. So helpful. Thank you, Winnie. And I hope you guys will all treat each other with plenty of respect and
just for purposes of timing here, this is
Yes,
right
sir.
idea. She's gonna email those that agreement, and then everybody obviously has to have a few minutes at least to look at the agreement. Should we be when should we be calling? Should we be calling it right now, in 5 minutes, in 10 minutes?
There's no calling. Just leave the Zoom running, and then at
No, I'm
11:20.
talking about, you said to have a conference off the record, so we're going to call into this
Yeah.
800 number.
I'd like you to have that agreement in your hand, and I'd like that. Well, we're off the record right now, so I have to be careful in what I discuss with you guys off the record. But
I'm just asking for timing. That's
it's all
all.
council here. All council's still present, right? Nobody dropped off. Okay, what I'm hoping is when, frankly, Mr. Bartel, who made the, well, I had to drag the motion out of him, but he implied that he was wanted to do some driver because he needed it. Once he has it in hand, actually, we've just extinguished the basis for his motion to postpone. I don't know that that's going to happen, but it may. And that's what I was a way of resolving that issue so we can go forward.
All right,
Mr.
Mr.
Higgins?
Padilla, may I suggest that we call into the conference line at 10:40? Will that work?
That works for me. I was just trying to get a timeline.
That works. And Annie, can you repeat the code? I'm sorry, I didn't get it all.
No problem, Fred. It's 690-9737.
Thank you.
Thank you, everyone. See you all at 11:20. Bye-bye.
Mr. Lennon, are you back?
Hello, everyone. It's 11:25 a.m. I'm a little late to the table. Are we all present? Let's see. Mr. Martel, Ms. Maggioni, Mr. Borman, Mr. Maurer, who I don't see him or hear him. Here he might be coming on. There's Mr. Padilla. We've got witness Casper. We need witness Graham. There he is. Hi there. Glad you're there. Christopher Ryan is still with us. Ms. Dunn is on. Ms. Archuleta. Mr. Maurer, are you there, Mr. Maurer? Maybe not.
Yes, sir, I'm here.
All right, great. Geez, I was doing something very dangerous. I was reading law for the entire hour we off. That's very dangerous.
Yes, it is.
Actually can learn things. Okay. Are we ready?
I
Did we?
can't see Mr. Maurer.
Yeah, I can't see him either. Mr. Maurer,
Oh,
maybe
sorry.
are you plugged in? Is your camera plugged in?
There.
Hey,
There you are.
you look good. Okay.
Get challenged.
Next challenge. Okay, I think we have everyone. And when we left it off, we were going to exchange what I received, which was the settlement agreement between the city and AMR. I take it everyone received it. And did you guys all connect by telephone and have a nice congenial telephone conversation? We're off the record, Miss Allison.
We had
you
a
guys
telephone conversation.
You had a nice telephone conversation. That's good. Thank you, Mr. Borman. I was hoping Ms. Maggiore would say that she had a nice telephone conversation. Is everyone getting along with each other now? How about Mr. Borman? He's easy. An answer?
It depends, I guess, on what, how you define all these terms, but it was a lively discussion.
Geez, that was such a lawyerly answer. You scare me.
Well, I can tell you, here's what I could tell you, and I think everybody would agree with this, is that we did not reach a resolution.
Okay. All right. Well, I'm going to go back on a record unless there's some reason we shouldn't. Anybody have any reasons? No. Okay. Ms. Hoyman, please put us back on the record. Thank you. All right. Thank you, everyone. We are back on the record, and it is now 11:27. I was a little bit late returning after our hour-long break. It was a working break. I hope it was a working break. It was a working break for me. And I understand the parties, council have all conferred by telephone, but they have not reached a resolution. And we also had left about an hour ago with the planned distribution of the settlement agreement between one of the city of Santa Fe, who had filed the motion to withdraw their intervention. Anyhow, their status as an intervener. Mr. Bartel, has anything been resolved in your opinion? Because I think you had an issue with going forward without knowing the content of the settlement agreement.
Thank you. I think that seeing the settlement agreement has been very helpful. And my proposal and the offer I made to council is that we proceed with the hearing as it is currently scheduled, but that Albuquerque Ambulance Service be given the opportunity to seek a subpoena for Chief Suber on behalf of the Santa Fe Fire Department, and that he be subpoenaed to appear at this hearing at some future date when it's convenient for all parties and Chief Suber to hear from the city. And we can proceed, to get as much done today and tomorrow as we can, and then follow up with Chief Suber. That's my proposal.
I hear your proposal, and it was not reached, an agreement was not reached on your proposal, correct?
That's correct.
Okay, thank you. Does anyone else have any other comments about your distribution of the agreements, documentation of the settlement agreement, and the proposal of Mr. Bartel? Any other comments?
I can say that I completely disagree with Mr. Bartel. Again, that's looking to delay the hearing. There's nothing in the settlement agreement that has anything to do with the kinds of issues that are suddenly being raised. All of a sudden, we need different witnesses. My position, and I believe that Mr. Borman agrees with this, is that each party is responsible for bringing in their own witnesses. And to rely on another party to bring in a witness who may and may not show up or may and may not be there is not the way I practice law, and not the way I've seen most people practice law. All of a sudden now, Chief Suber has become an essential witness, and he's so important that nobody bothered to bring him in. So I don't really understand that. And again, I think it's just a means to delay this hearing. If we don't finish this hearing in the next 2 days, we're looking at the holidays. We're looking at the potential for another shutdown. I've just heard that the Supreme Court has extended the ban on jury trials for at least another month. And I heard that because I have a trial that's supposed to go on the 4th of January that is now not going to be happening. So I think we need to get through this, and I think we need to make it happen. And I think we have everything we need right here to make that happen.
Mr. Borman, you were going to say something?
What I was going to say is I believe that Mr. Montoya is in the waiting room. If you could check to see.
Oh, okay. Let's see. Is that Jason Montoya? Yeah, we have
Yes.
2 Montoyas in this case. So there he is, and I will admit
Jason
him.
Montoya. All right, thank you.
Mr. Hearing Examiner, this is Fred Maurer. My
Yes, sir,
only problem with this is the agreement. It has language in it, and this is going to be in the record, that there is a need for interfacility transportation services, yet in another paragraph says the agreement should not be construed as precedential or persuasive with regard to any principle or issue raised in this proceeding, which goes to the issue of need. And so I think Mr. Bartel is right. We do need to hear from that witness and the city's position as to why this language was placed in here, finding that those conflicting positions. Thank you.
Thank you. Any other comments from council?
This is Ray Padilla, Mr. Hearing Examiner.
Hi.
I agree with Mr. Maurer, and specifically paragraph D of the recitals. The language in there goes directly to what this hearing is all about. It talks about the parties agreeing that the agreement will result in the equivalent or improved service for all citizens, and that goes to the decision that you have to make recommendations on, and it goes to the heart of this particular case. But beyond that, there's other issues that are raised by this agreement that would have to be placed into evidence. If this agreement is going to be part of what's in evidence, and I think even Mr. Borman agrees that it has to become part of the record here, then I think the agreement has to be fully explained. And the only way to explain that agreement is through Mr. Zuber, I presume, even though he's not the one who signed the agreement. I don't know whether he took part in the negotiations, but we may have to figure that out. But this agreement does no good, in my opinion, without an explanation as to how it was reached and why it was reached. The agreement specifically says that the agreement was reached in consideration. So obviously there's consideration that was exchanged between AMR and the city. And if that consideration goes solely to the benefit of AMR, after the city had presented written testimony that was favorable to the position being taken by Albuquerque Ambulance and Superior and Rocky Mountain, then this is an agreement which is prejudicial to all of us. I mean, I could go on, but I think there are issues pertaining now. There's even more issues in my mind with regard to the agreement, how it was reached, and what effect it's going to have on what you're ultimately going to have to make recommendations on.
Thank you, Mr. Padilla, and thank you all, counsel. They're all good arguments, and obviously you're, as I said, advocating on behalf of your clients. In my chair here, it's important to keep track of under which walnut shell the P remains, and I've tried to do just that. I'm going to rule on the motion to postpone, and then we're going to move on. I'm going to deny the motion to postpone. We're going to continue with this case today. All of your objections have been noted. They're in the record. If you feel it has been a prejudicial ruling, that would be up to you to prove the prejudice if you're going to file an appeal based on my ruling. But the motion to postpone is denied, and we're going to move forward. The next thing I have on my agenda is the second motion for consideration, not for ruling yet, but for consideration. And that's a motion that I became aware of last night at 11 p.m. on Sunday evening. I often work on the weekends and I often work on the evenings, but this particular weekend I didn't open up my business email from Saturday morning till Sunday evening. And that is a motion to deny the continuing status of Rocky Mountain as an intervener. And Miss Majori, Susie, I'm going to call you Winnie if you don't mind. That's easier for me to pronounce. Winnie, if you would care to argue your motion, I'm all ears and ready to hear it. And then we'll hear from the other parties, and I'm sure they will not interrupt you. Thank you.
Thank you. At approximately 4:30 in the afternoon on Friday, I listened to the very end of a hearing before the full commission in case number 20-00181-TR-EN. This was an enforcement case that has been ongoing for some time. And the full commission heard it on Friday. It's my understanding it was a full day hearing. I didn't attend the full hearing, but I did attend the last portion of it where the commission ruled unanimously that Rocky Mountain was immediately suspended, and that suspension would likely last until the full hearing, which I believe is scheduled for April. And without going into the trail of tears that is outlined in there, without question, Rocky Mountain's status has changed, and it no longer meets the statutory or regulatory requirements to be an intervener. It doesn't have territory to protect at this time because its operational status has been revoked. And I think that's really important because it would be very prejudicial to my client to have Rocky Mountain continue to participate here as an intervener, to make arguments, talk about subpoenaing witnesses, delaying our hearing and everything else when it is not a functional carrier at this time. I don't think that would be appropriate. I think it would be prejudicial. I think it would be error to allow them to continue. I can either do this now or do it later within the hearing, but I'm going to be asking you to take judicial notice of what did happen in the hearing in that case. If you prefer not to do that, I will have a lot of questions to ask to get that evidence into the record. But that's my argument. Thank you.
Thank you. Before the council respond, I have just a couple comments. One, it's administrative notice. Secondly, you were referring to administrative notice of what? The holding yesterday?
That for sure.
Okay.
I would be asking you to take judicial notice of 2 filed complaints but particularly of the investigative report that was filed by PRC investigator, Transportation Division investigator James Montoya, that was entered into the record in that case.
Okay. Are you so moving, or are you just mentioning that you're going to do that?
Well, I will so move. It'll probably be easier to deal with everything together. So yes, as part of my motion, I would move that you take administrative notice, and I apologize.
Okay, let me roll. You're welcome to remove RE-move later, but right now I don't have it. I don't have access to it. You probably don't have access to it.
I do.
Well, I don't have it. So if you want to send it to me and send it to all the parties as an exhibit, as we've been circulating exhibits, do that this evening. Then tomorrow you can also move again for the administrative notice, and we'll deal with it tomorrow. But for today, it's denied for those practical reasons. Secondly, I anticipate there's going to be legal argument against your motion. So, and this argument has been going off in various tangents throughout the day. I don't want this further legal argument to go off the tangents, but to prevent it from doing so, I have two questions before I forget. Do you make any distinction between suspension and revocation of the certificate issued to Rocky Mountain?
Yes, my understanding is that they are suspended. My understanding is that they have not been revoked, but that they have been suspended for a period of time, most likely to go until April of 2021.
And do you believe, for your purposes, that suspension is equivalent to revocation?
No, my understanding of revocation is that revocation is permanent. Suspension, there can be a motion to lift the suspension. That has happened to Rocky Mountain before. I anticipate it probably will happen again now. But the issue for us in this hearing is that about, I think it's 1,400 to 1,500 interfacility transport calls a year just got put back on the table that would not have been there otherwise.
Okay.
I understand this suspension could be reversed, but maybe it will be, maybe it won't be. And I don't think we can prognosticate as to what's going to happen there. I think we have to deal with what's in front of us. And what's in front of us right now is that they are no longer able to operate as a carrier in the Santa Fe area.
Okay, and could you please cite your authority for your argument that they do not satisfy the requirements to remain an intervener?
Sure, let me pull out my motion. Give me 1 second here. You know what? I think I accidentally tossed it. All right, the citation, the motion is filed pursuant to section 1.2.2.12A1.
I think that's the general motions one.
Okay.
I wanted the one that says that a party cannot remain an intervener once they've been granted intervener status.
Well, I think that's a different question. The question for my motion is the intervention was granted on the grounds of section 1.2.2.23D2A. And it was granted on the basis of Rocky Mountain EMS having a substantial interest in the proceedings. Under subsection B, the participation of the intervener is substantially in the public interest, which if they are not an operational carrier, it would not be in the public interest. And under subsection C, intervention presents no undue prejudice to other parties. I think at this point, intervention by a party, let's just put it this way, if Rocky Mountain were to move to intervene today, I doubt that that intervention would be granted.
Might agree with you, but I'm looking for the authority for me to remove them as an intervener. I've had some trouble finding it, to say the least, and I was hoping that you could help me out with that.
Well, I haven't had a chance to look because, as you know, this happened at 4:30 on Friday afternoon, and I did spend the weekend preparing for the hearing. I believe that as a hearing officer, you do have the authority to grant intervention, and along with that, you would have the authority to revoke or remove the intervention status because of a change in the party status.
Thank you. All right. Anything else, Ms. Maggiore?
No, thank you, sir.
Thank you. And I'm going to go out of the normal order if you guys don't mind, because I think the real party in interest would be Mr. Padilla's party. I'm going to allow him to respond to your motion first. Does anybody have any objection to that order? No. Okay. Mr. Padilla, would you please respond?
Thank you, Mr. Hearing Examiner. First, let me respond to what Ms. Maggiore has said. I know you've already denied what she said with regard to taking administrative notice of certain testimony, but Ms. Maggiore said the report of James Montoya. It's actually James Martinez. It's not James Montoya.
Oh, I apologize. I saw the big J, James, and so I apologize. James Martinez.
Okay.
Thank you, Councilor.
I just wanted the record to be clear, Mr. Hearing Examiner. So the motion itself is to revoke the intervener status. And I would first point out that the intervener status was granted by the commission as a whole. And while I don't have any specific authority to cite, I think there's an issue as to whether the hearing examiner has authority to overrule a commission order. There's a specific order that says that that my client should be allowed to proceed as an intervener. And it would seem to me that from a procedural standpoint, if that order is going to be overturned, it should be overturned by the commission as a whole. And I can tell the hearing examiner that while Ms. Maggiore has been talking about what happened last Friday, the commission did not address whether whether it would affect this particular case. What the commission did do is the commission said that the case in which the order was entered, which is it's an unusual case. It's been split into two parts. There's a part that's before a hearing examiner who's been appointed and has to enter proposed findings of fact and conclusions of law and a proposed determination. But this aspect of it, the commission stepped back in and took it over. But the part with the hearing examiner is still ongoing. And at least as I understand the commission's order, the hearing examiner still has to make recommendations as to the ultimate question of whether Rocky Mountain's license should be permanently suspended or revoked. And quite frankly, I don't understand the distinction between permanent suspension and revocation. I think they're exactly the same thing. Permanent suspension means your authority's gone, and revocation is obvious. But anyway, that issue is still ongoing. That case is still ongoing. There's a lot of things in Ms. Maggiore's motion itself that either I don't think have anything they're not relevant, they don't have anything to do with your decision, but or they're incorrect. But for example, with regard to paragraph 2 of the motion, it makes reference to the direct testimony of Mr. Smith, and it says who's no longer employed by RMEMS. I don't think that's relevant. Mr. Smith testified in the Helios matter. Of course, he has to be accepted as a witness in this particular case, but his direct testimony has nothing to do with whether or not you should be revoking the status of the party. The motion at paragraph 4 said that Rocky Mountain said that it was willing to provide the service. Well, that hasn't changed. What's changed is that the commission has entered an order which presumably alters what happens even if Rocky Mountain is willing to express. But as Ms. Maggiore has admitted, my client can file a motion to lift the suspension, and I don't want to get into that and be specific, but I can tell you that is actually going to take place. And if in fact the commission deems it appropriate to lift the suspension, then Ms. Maggiore's arguments about this suspension kind of go away as far as that's concerned. The motion makes reference to James Martinez and the other case. If we get into James Martinez and the other case, Mr. Martinez actually filed 2 separate reports in the other case. There was another investigator by the name of Vince Crispin who filed a report in that other case. There are 2 individual complainants who filed formal complaints in that case. They're ex-employees of Rocky Mountain. That case is not scheduled to go to hearing until April the 12th of this year. And then, of course, there's going to be an opportunity for findings of fact and conclusions of law, I presume, and then an ultimate recommendation, an ultimate decision. So that might even go beyond that. But in any event, who knows what's going to happen as far as Mr. Martinez and his statements, and whether or not those statements are even going to be considered, because the commission has entered an order, and I'm not sure whether it was the commission or whether the hearing examiner, but there's an order in place in that particular case saying that testimony that was taken in that case is essentially going to be adopted. Testimony that was taken last Friday is essentially going to be adopted for purposes of this hearing that's going to take place on April the 12th. And that hearing is actually set for a full week. It's set from April 12th through April the 15th. We disagree that Rule 1.2.2.23 D2A controls here. Ms. Maggiore talks about a substantial interest. Well, this is in fact a suspension, and I think that to answer your question about a distinction between suspension and revocation, yes, there is legally a distinction, a clear distinction. Suspension doesn't mean that Rocky Mountain EMS doesn't continue with its certificate of authority. The certificate of authority is still active. What's been affected by the commission's decision, and again, there is no filed order. The commission expressed an oral determination on Friday. There was a motion made. It was a somewhat limited motion, but the motion clearly was to immediately suspend the ability of Rocky Mountain to operate. But that doesn't mean that the certificate has been revoked. So I think that Rocky Mountain does in fact have a substantial interest, because it still has a property interest in an active certificate of authority. Whether this is in the public interest is ultimately a determination that you have to make, and whether there's undue prejudice to other parties. I would suggest that the prejudice is extreme with regard to Rocky Mountain, not to allow it to participate in this particular matter. I don't see where the prejudice falls with regard to AMR, because AMR has been aware of Rocky Mountain's presence in this, and until Friday afternoon, AMR didn't have anything to complain about in this particular matter as far as our participation is concerned. And it's kind of interesting, because we just argued this other motion with regard to the city of Santa Fe. Well, these two things both happened after 4 o'clock on Friday afternoon. So here we are with a second issue that's an 11th hour issue. again, Ms. Maggiore says that we don't meet this. She says we don't meet the statutory requirements, but she hasn't cited a statutory requirements which says that you have the authority to reverse the intervener status. She's relying on a rule, but the motion itself says because of its suspension, RMAMS no longer meets the statutory requirements. And I agree that she does cite to the statute when she makes reference to 65-2A 13C2, but that's an issue as to burden of proof, and that's something that you ultimately have to make a determination as to whether all of the parties, not just Rocky Mountain EMS, has met the burden of proof in this particular matter. And the statement that Rocky Mountain no longer has a territory to protect is just totally incorrect. They clearly have an authority, a territory to protect. I think it's inappropriate that that their status as an intervener be revoked for many, many reasons. And I don't see the prejudice. And I think that with regard to the testimony, you can make the determinations as to whether or not burden of proof has been satisfied, and you can make the determinations as to weight to be given to evidence. That you should be following the law and the statute and the regulations in this particular matter, and you should not grant the motion to revoke the intervener status of Rocky Mountain.
Thank you, Mr. Padilla. Can we hear from you, Mr. Maurer? You need not make an argument, but if you care to. Can't hear you. Muted.
How's that?
That's there. You're there. You're here.
Very quickly, Mr. Hearing Examiner, the problem is we don't have an order. So it'd be nice before we make all these arguments if we could see what the commission's actual order says. Number two is the prejudice it creates going both ways. It creates potential prejudice as an example for Superior, because if testimony is prohibited or allowed into this record, and those decisions are reversed down the road because of a state Supreme Court ruling and or a state district court ruling, the parties then face a dilemma with the record having information in it that goes and should be eliminated. That also applies to AMR. If in fact there is evidence admitted, which it is subsequently determined it shouldn't have been, AMR's record now is contaminated. And if, as an example, you deny the application, there could then be placed into jeopardy your ruling, and we have to do this all over again. Lastly, I think Mr. Padilla, before, if there's any issue concerning this with regard to all parties, should be at least given a chance to file some type of written response so that it's in the record what the position of his client is. Thank you.
Thank you, Mr. Bartel.
I concur with the remarks about this being premature. There is no written order. I'm looking at the docket for the cited case that Ms. Maggiori's motion refers to. No order has been entered. And I think as a result, the hearing examiner doesn't have sufficient evidence on which to rule on this motion at this time. And I also share the concern about what happens if a decision is made to exclude Rocky Mountain EMS and then that is reversed. You know, it's not only going to disrupt the proceedings in this case, but it could have a potential effect on the ground as well. So if AMR believes that Rocky Mountain's status needs to be determined before we can proceed, then I guess we should postpone this hearing and let that motion get fully briefed and decided.
Thank you. Mr. Borman?
Thank you, Mr. Hearing Examiner. I'm not going to restate a lot of the things that others have mentioned already, you know, about this being a suspension rather than a revocation. And at least to my knowledge, it is accurate to say that there is no order that has been issued by the commission. They have deliberated on this and I think agreed to take a certain, to decide in a certain way, but they have not issued an order to my knowledge. One thing I would note is that I'm not, and while I don't know that staff really takes a position on the motion one way or the other, I would note that I think Rocky Mountain, is at least allowed an opportunity to intervene, even if it's not a full service provider. I mean, the statute provides not just for protests by providers who are impacted, but also it provides for objections that can be filed by an interested person or member of the public. And as such, I mean, I think even if you were to say that Rocky Mountain's suspension might prevent it from being a protester, I think at the very least, it probably could participate as having its, I guess, protest considered an objection at this point. So again, we don't take a position, but I wanted to point that out to you that I think that ought to be considered.
Thank you, Mr. Borman. Okay, that being the argument of all counsel, I'm going to say a few things and then actually going to roll on this motion. The other one, we're keeping it, holding it in abeyance. But on this one, I'll have a few comments. One, when I was practicing law, I never missed a chance to use a big fancy word if I could when I was writing briefs and such. And one of my favorite big fancy words was inchoate. Inchoate means it's one way of thinking of it, it's not ripe yet. And I think we may have a situation where I could easily weave the word inchoate into my paragraph if I needed to write a paragraph. I looked at the motion and I was thinking, I should tell you, I attended the meeting on Friday as public, and I listened, and I heard the end, and I heard that there was a suspension. So what immediately came to my mind on Friday was, well, how could a party prove a full service operation if they're suspended? That's what came to my mind. It still remains in my mind. And I think that may be something that could be raised in the merits portion of this case, perhaps, and I'm not telling anybody how to do their job, but during the examination of Rocky Mountain's witness. But that's not what we're dealing with right now. That's what came into my mind Friday afternoon, late Friday afternoon. And then I checked my email, like I said last night, and I got this motion. And I was thinking, seems a bit tardy. And then, of course, it deals with just Friday. And I realized why it's a bit tardy. Then I pulled out the regs, and the regs say that they have to be filed in writing, and they have to be in writing filed before the hearing starts. And then it all seemed to come together to me. Why am I getting this over the weekend for a hearing that starts on Monday? That makes sense. Now, procedurally, I usually wait about 15 days to give other parties a opportunity to respond to motions. And this would be that type of motion. So the timing is something that's far beyond the control of us. It just happened to work out the wrong way as for allowing the 15 days. So normally that would be a pretty big concern. I want everybody to have an opportunity to be heard, if for no other reason, as Mr. Maurer accepted the telegraph wisely, I want to destroy any possible appeal avenues. But I'm not so concerned about it in this particular case. And the reason I'm not concerned about it is, and I'll disclose and then explain, I'm going to rule against the motion and allow Rocky Mountain to proceed. Now, obviously, they're not going to have any appeal based on that. The other parties, I think it would be a diminished argument, but I think it's the inchoate reason. A suspension is not a revocation. And that's why I ask Ms. Maggiore if she makes a distinction, and what is that distinction? I heard, I think it was Commissioner Espinoza announce the decision of the commission after they returned from the closed session. And she said that the certificate is suspended pending further action. That's what I remember hearing. And to me, that means just what it sounds like and just what it is expressly. It's not, there's no ambiguity there. There's going to be further action. In the meantime, until there's further action, there's a suspension. Does that mean that Rocky Mountain can't operate? Yeah, but until there's another order, until there's further action. So it seems to me that they are not revoked, which we don't need to deal with because we're not there. That may very well be an issue. But there's a suspension. So what is a suspension? In my opinion, a suspension is inchoate. It hasn't it's something that happens in the meantime until we're waiting for the main thing to happen. So I think Rocky Mountain still has a role to play in this case today. In fact, I think they have a right to proceed. Furthermore, I have a second thing that I want to mention. One of the reasons I looked at this closely, I don't believe that, I've made this argument myself in court, that judges should legislate from the bench. And I don't think that hearing examiners should promulgate regulations either. And I looked for the authority and I couldn't find it. And that's why I asked Ms. Maggiore for it. Frankly, honestly, I sometimes ask questions when I do know where they are, but this time I didn't know. Where was my authority to remove this intervener? And I couldn't find it. I disagree with one thing. I do think I have the authority pursuant to 1.2.2.23 D2 as the presiding officer, and I'm quoting those words, to grant an intervention. And then there's the 3 reasons I can grant it. I could easily, if I needed to, make an argument that the flip side of that same coin is without those elements, or at least one of the elements, I couldn't grant the intervention. But I read the same regulation again and again, and I couldn't find where a previously granted intervention could be stricken. And I couldn't find it where I would expect to find it, which would be right after that language in the regulation. Then I, of course, expanded the scope of the search a little bit, and I still couldn't find it in the regulations anywhere. So although I'm bound by the statute, I administer the administrative regulations, and it's not in the administrative regulations. So for basically 2 reasons, no administrative authority, and because the status of Rocky Mountain is currently inchoate, or inchoate, I've heard it pronounced. At this point, the motion to revoke intervener status of Running Bear Rescue Inc. doing business as Rocky Mountain EMS is denied. And now I think we're ready to move on to testimony. It's not time for a break yet. Nope, not yet. Are we ready to present the first witness? Mr. Graham, Ms. Maggiore, do you want 5 minutes to talk with your witness? He's been standing by all morning. Is this
if you don't mind, sir, I would like just a couple minutes.
I think it's a good idea. Let's all take a 5-minute now, even though we haven't been going for an hour. It's 12:08 on my computer. We'll be back. What's that math? 12:12.
Mr. Hearing Examiner, just for housekeeping purposes.
Yeah. No lunch.
No lunch today?
Just kidding. Is that what you're going to ask me?
Well, I was going to ask about lunch, but I was going to tell you, I think at the last hearing, which most of us took part in, you allowed a half an hour for lunch, and And obviously I'm not in my office and I can't really accomplish going somewhere to get anything to eat in a half an
Okay.
hour. So when it comes time, I guess I would respectfully request that the break at that point in time take an hour.
All right. It sounds good. When we come back in 5 minutes, then we'll go for another hour or so with this witness. See if there's a convenient break at that point. Are you asking to take your hour lunch now? I mean, we just took an hour. It was a working hour, but do we have any concurrence? Does anyone else want to take their 1 hour break now before we start this witness?
I'm not asking for it now. I was just asking for
Okay.
when it happens. I'm willing to comply with whatever you want to do as far as proceeding. I'm not going to fall over if I don't get something to eat right now.
Okay.
I just wanted to clarify timing.
Thank you. I once was similarly trying to push a meeting along with a short lunch break, and then someone told me that their witness had diabetes and it was medically important that they eat. And I recognized my how can I put this, that I wasn't sensitive enough to that diabetes possibility. So, I'm not saying you have diabetes, but we'll probably take a little longer time unless there's any objection. But we're in my perspective, we're a bit behind. We've been arguing motions and we haven't even started testimony, and it's noon already. So I want to push it so that we can finish by tomorrow afternoon before 5. That's I believe a realistic goal. Okay, so 5 minutes and we'll be back and we'll start with first witness. Thank you. 5 minutes. Mr. Mauer, are you hiding in that corner over there? Hey, there you are. Okay. I was waiting for you to return, but you're there. Okay, then
Oh, I'm
Mr.
sorry.
Bartel, I see him there.
Sorry.
I think we've got everybody back. So instead of using any time up, Mr. Hoyman, can we go back on the record, please? Okay, back on the record. It's now 12:24 according to my computer. We took a short break, and before we begin the testimony, I want to make an announcement that I acknowledge that we could have public comment at this point. I haven't received notification that there would be anybody that wanted to publicly comment. So I just wanted to acknowledge that or put on the record that has not been forgotten. I think we're ready to go. Ms. Maggiore, do you want to call your witness? Or maybe you want to move to admit the application?
There we go. Can you hear me now?
I can hear you now.
Okay.
And I received two applications, one redacted and one not redacted. I don't know if you want to address that or not.
Okay, I'm not real sure what that's about, but we would like to move the application into the record to the extent that that needs to be done. I so move.
Any objection? Okay, the application, the
Hearing examiner,
unredacted.
I
Yes,
don't
sir.
have any objection. I don't have any objection, but which one are we moving? Both the
unredacted.
unredacted and redacted?
The unredacted.
And I was about to admit the unredacted version sua sponte anyhow. So the unredacted version is admitted, there being no objection. Thank you. Please proceed.
What number is that?
One, unless
Okay.
you've got the other things labeled differently, Ms. Maggiore. I don't think so. Do you?
I don't think so.
All right. I put APP number 1 on the front of it. That's what I do. So that's what I'm going to do.
Thank you.
All right, AMR would like to call Joaquin Graham.
Mr. Graham, I don't know if I've done this with you before, but I'm going to ask you to stand and raise your right hand. It's a bit of formality, but it helps. Mr. Graham, do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Have a seat and we'll proceed.
All right. Will you please state your full name and your current position on the record?
Good afternoon. My name is Joaquin Graham, and I'm the Regional Director for AMR in New Mexico.
Did you participate in the preparation of pre-filed testimony for this hearing that was served and filed on October 23rd of 2020?
I did.
And was that testimony true and correct at the time that you prepared it?
It was.
Is it still true and correct today as we sit here on December 14th of 2020?
It is.
Are there any changes to your direct testimony that you would like to make on the record today?
No.
All right. I would move to admit the direct testimony of Mr. Graham.
Any objections? There being no objection, I have one question, Mr. Graham. It's I thought I experienced like a little deja vu experience when I was reading it and wondered if you wanted to make a correction. I was reading pages 5 and 6, and I got to line 7 on page 6, and it seemed familiar. And I was wondering why it seemed familiar to me. And then I paged back to page 5, and it looks like, with the exception of one word, need, N-E-E-D, it's exactly the same language that begins on line 18 of page 5. And I was wondering if that was just a typographical error and you wanted to strike one of those two, because it could cause some question about the rest of your testimony. It's that it's perhaps overproduced in that exactly the same words are used twice in the same testimony. Am I missing something, or are you seeing what I see?
No, I see what you see now. Yes, sir.
So it's seems unusual that someone could respond in an answer and respond with exactly the same words immediately following each other in response to the same question.
Yes, sir.
If that's a typo, you might want to clean it up. If not, you can let it stand
I
as
believe
well.
it is a typo, Your Honor, and or Mr. Hearing Officer. And let's keep the one with the word need in it, and we can strike the duplication. I'm not sure how that happened.
Okay, so you're going to strike page 6, line 7, beginning with the word when.
Yes, through 14, ending with Santa Fe.
Through 14, ending with Santa Fe. The reason I ask, and thank you, that's so stricken, and it is admitted. Now I'll just give another comment. There is one word that was different, which is the word they was substituted instead of Christus in the first one. It's not substantial, but obviously there was some manipulation of the words there. And I just wanted to mention that I noticed it. And when I see those kind of things, I wonder how much post-production effort has gone into these statements of the witnesses. So with that language stricken, there being no objection, this testimony of direct testimony of Joaquin Graham is admitted as applicant's APP number 2. Okay, wait a minute. Did you pre-mark? I have a stack of ones that you guys sent me just last few days. Did you pre-mark that one, Ms. Maggiore?
I don't believe we pre-marked them.
Hold on just a second. You guys won't believe this, but I have 2 stacks of papers here. One that was filed and I've reviewed, and a second stack, which is what I call the potential evidence stack. And those are the ones that have the pre-marked exhibits. Huh. No, I don't think so. So I've just marked it APP number 2, and that's what it's going to remain. Thank you. Sorry for my confusion.
Mr. Hearing Examiner,
Sir.
The exhibits that I copied from the email that Ms. Maggiore sent me, they have AMR 01, 02, 03, 04, and 05 on them. I don't know whether that was just an email that didn't get sent to you, but I have exhibits that have at the bottom, it says AMR 01 and through 05.
I thank you, sir. That's it's interesting, but I don't mind. Yeah, I have similar things. I'm holding them in my hand. I just found it. It was my mistake. I do have it. It's marked. I don't know if you guys can see this. AMR1, but that's consistent with what I just marked. So there's really no, it's a distinction without a difference. So thank you, Mr. Padilla, for pointing that out. I've got so many papers here, sometimes it's difficult to keep track.
So are we going to have then APP 1 and AMR 1 through 5, or how are we going to do that?
We'll have APP 1 because that's what I just marked and that's what I just put on record. And I'm not going to admit AMR 1. We're going to put that aside. APP 1 is the one that got admitted. Thank you.
Well, AMR 1 that I have is the direct testimony of Mr. Graham, and that hasn't been admitted. APP 1 is the application itself. I just want to make sure when I'm following this thing that I know where I'm going when I decide to ask my questions. I don't have a problem with having the application be APP 1 and the rest of them be AMR 1 through 5, but I just want to make sure we're talking about the same thing and that I'm following what's going on.
Thank you, Mr. Padilla, for keeping me in line. We have APP 1, which is the application, We now have a document which is marked AMR1 and APP2. I think everybody can see that on the screen.
Okay.
APP2 is admitted evidence with one part of a paragraph stricken as explained in the testimony. I don't mind you correcting me and keeping me clear. Appreciate it. Okay, finally, do we have? There's no other. You don't have any other exhibits, right, Miss Majori?
I do. I have the direct testimony of the two witnesses who will be appearing tomorrow.
Right. Well, we're not going to admit those now. So
Oh, no, we're not going to admit those now.
Nothing with this witness.
No, nothing else for this witness.
Let's move on. So let's see what order we're going to do. I suggest we be consistent. We'll go with Mr. Maurer for Superior. Then we'll go Mr. Bartel for Albuquerque. And then we'll have Mr. Padilla with Running Bear. Okay. And then staff.
This is Fred Maurer. With the indulgence of Mr. Bartel, could we flip? I need to take care of something very, very quickly. I don't want to stop the process, but if Mr. Bartel could start, then I'll follow him.
Well, I want you to be present through the entire proceeding. So if you have to leave the room and you can't attend, I'm going to stop the proceeding. Do you need to leave the room?
No, I guess not. I don't want to stop the proceeding. We spent a lot of time today. I just wondered if Mr. Bartel would indulge me and start so I could do something very, very quickly. I don't need to leave the room.
Okay, Mr. Bartel, do you mind going now?
I'm fine to proceed.
Thank you, Mr. Bartel.
Go for it.
Mr. Graham, are you familiar with the request for proposals that the Christus witnesses that are being sponsored by AMR have referred to in their testimony?
Object to the form.
Overruled. Go ahead.
Yes, Mr. Bartel, I'm familiar with the RFP that Christus released.
What was the date of release of the RFP?
That I don't know. I would, it's in direct testimony somewhere, but, or in rebuttal testimony, but I don't have the date off the top of my head.
Do you have a time frame for when it was released?
November, December.
Of 2019?
I'm sorry, November of-ish, October, November of 2020. Or, yeah, I mean, I can't recall the date. Can I refer to some pre-filed testimony or some responses?
You can refresh your recollection and then you can close up whatever you're looking at. Is that okay, Ms. Maggiore? He's your witness. Have you refreshed your recollection, Mr. Graham? And do you now remember?
No, I still don't remember the date.
Okay, well, that's the answer then. That's fine. He doesn't remember, Mr. Bartel. Next question.
What information did Christus provide to the parties who were invited to respond to the request for proposal?
I don't fully understand your question. What do you mean, what information did they? It was a typical request for proposal, said that they were seeking ambulance services to support the need that they had for ambulance services at Christus St. Vincent. And that was generally, like any other RFP, what's in it?
Well, generally an RFP tells the responding party what it is that the requesting party, the party that's sending it out, wants to get in return. What did they want from the responding parties?
They wanted safe, adequate, reliable ambulance services that they could consistently count on.
And did they state in the RFP that they intended to enter into a contract or an agreement in the furtherance of obtaining ambulance service?
Well, I don't know that it's stated in the RFP specifically that.
Well, what was the end result going to be? That's what I'm trying to understand. I've never heard of a request for proposals for ambulance service in the state of New Mexico before, other than when a public entity is going to lease its certificate. So I'm trying to understand what it is that you responded to when Christus sent this out. So what was it that Christus wanted as expressed in its request? What did it want from AMR?
Well, it wanted of all of the folks who responded, it wanted a description of how that particular ambulance services could provide interfacility dedicated ambulance services for Christus St. Vincent's. And like most RFPs, I say it also implies that the winner of the RFP is going to enter into a contract with the hospital. And it gives the opportunities for the ambulance services to highlight what they can bring to the table.
Was a copy of the proposed contract attached to the RFP?
What proposed contract?
You said that it implied that there would be a contract. Did they actually attach a form contract or a proposed contract that would be the result of the RFP?
There was no attached contract or proposed contract. And in fact, what I said, though, is that an RFP typically implies that there will be a contract that is entered into between the winning party and whoever solicited or put out the RFP.
Now, apparently, Christus announced that AMR was the winner, for lack of a better word, of this RFP process. Is that true?
That's true.
And how did they announce this?
They sent an email.
And from the time that you got the email to the present, has a written agreement been formulated?
No.
What specific commitments did Christus ask for in the RFP by way of capacity to perform interfacility transports?
There were no specific asks that I can recall of the RFP. Essentially, they, again, invited the different applicants of the RFP process to really be able to highlight how they could support St. Vincent's through ambulance services.
Did AMR assist Christus in preparing the RFP?
No.
In your direct testimony, you state that AMR anticipates 2,000 transports annually. Is that a figure that came from the RFP released by Christus?
That in conjunction with what we assume would be additional trips that we would be able to pick up in the Santa Fe area.
How many trips or how many interfacility transports did Christus's RFP identify a responding party should be prepared to undertake?
I don't recall the exact number, Mr. Bartel.
Something less than 2,000.
Yes, sir.
So in your testimony, when you refer to projecting 2,000 transports, how many of those is AMR projecting would originate at Christus?
I think we assumed 15 to 1,700 of those total 2,000 would come from Christus St. Vincent's.
How many of those calls, the 1,500 to 1,700, how many of those calls are currently being handled by the Santa Fe Fire Department?
I don't know, sir.
how many of those calls are currently being handled by Rocky Mountain EMS?
I don't know how many. I assume, or I believe the majority are being handled by Rocky Mountain, or were being handled by Rocky Mountain up until Friday when they were told to stop operations in Santa Fe.
Mr. Bartel, could you clarify something for me? Because you were speaking with prospective numbers, and then you somehow switched over to ones that are currently being handled. And I missed that transition from prospective to current.
Well,
Understand what I'm asking?
You're correct. I mean, all I can look at is what is in Mr. Graham's pre-file testimony, and that says that AMR is anticipating 2,000 calls annually. I'm just trying to get an idea of what what the mix is currently, if he knows.
Okay, that's a completely different topic. And I didn't hear a segue, which I would have expected. And I just was wondering where that switched over. And I didn't want to interrupt your testimony. I just want to be clear. And I wasn't clear at that particular moment. I didn't want to let it go.
Well,
okay, Mr. Bartel.
And I do want to address that. So the 2,000 interfacility transports that AMR is projecting, if it's authorized to provide service, is that going to reflect any material increase from calls originating at Christus as compared to what the situation is now, setting aside the COVID emergency, which is a temporary situation? I'm talking historically, if you know, is the 2,000 call volume reflecting what is happening today, or is there some change in that call volume that AMR has included in that projection?
It was a long question. So the 2,000 that we projected, I think it's fair to say, is from our assumptions historically accurate, right? That we don't anticipate that the 2,000 is there today because of the COVID pandemic. That 2,000 we think is consistent with historic numbers.
So in that context, then do I understand that you do not know how many of the 1,500 to 1,700 included in the 2,000 calls per year are currently being handled by the fire department as opposed to Rocky Mountain EMS?
Well, there'll be zero because none of them are currently being handled because they're all in the future. This is where I had a bit of a problem with the testimony. You know, it's how many of the 2,000 projected into the future may in the future be handled by the fire department. Is that what you're asking, Mr. Bartel?
No, I'm trying to get a picture of what information Mr. Graham has as to how the call volume is currently being dealt with. Because I think that if I'm understanding his testimony, he said that the overall number is based on historical figures, which would suggest that there's a current call volume that's the basis for the projected call volume. So
I got it.
Okay. So, and Mr. Graham, just to clarify, do I understand that you're not increasing or escalating the projection to get to 2,000 as compared to what is the known historical call volume? Do I have that correct?
Object to the form.
Yeah.
Hold on a
I had
second.
a lot of trouble following.
Don't
the
answer yet,
question.
sir, please.
All right. Let me re-ask the question.
Yeah, thank you. That solves that.
So you
Sustained.
projected 2,000 calls annually. I'm just asking whether in getting to that projected number of 2,000, AMR has increased or escalated that number above what is the current call volume.
So I understand you to be asking me to say what the current call volume is and then whether or not the 2,000 we projected is an increase above that?
Yes.
Okay. I don't know what the current call volume is. The 2,000 is what we project to be the annual estimated transports should we get into Santa Fe.
All right. And you indicated that your projection is based on historical numbers. Is that correct?
In part, yes.
Okay. And in part, what else did you consider in going to 2,000?
So the parts are, of course, the numbers that we anticipate we would get from Christa St. Vincent's on top of what else an ambulance service with the number of trucks that we planned on deploying could handle. So we think that 2,000 per year is a good estimate of the type of transport numbers that we would see annually.
So underlying that assumption is the expectation that if you had authority in Santa Fe County, you would not only capture all of Christus's work, but then you would add some additional work from other facilities. Is that correct?
That's correct. But it miscategorizes to say we would capture all of it, right? That's always, I think, a slippery slope. We would capture the majority of it, but no service can always capture all of it.
The 1,500 to 1,700 that you project coming from Christus, is that an historical figure?
Yes, sir.
Did Christus differentiate in its request, to which AMR responded, between quote unquote emergency non-scheduled transfers as opposed to non-emergency non-scheduled transfers?
No.
And is it your understanding that currently the fire department is conducting a substantial volume of interfacility transports of both kinds, emergency and non-emergency?
Well, the Santa Fe Fire Department responds to every emergency request for ambulance transportation in the city of Santa Fe. So my assumption is that, yes, they are handling all the emergency requests that are coming through the 911 system. Additionally, they're providing support to Christa St. Vincent's for scheduled interfacility transfers that require an ambulance service.
And are you aware of any plans by the fire department to reduce its participation in interfacility transfers, whether they are emergency or non-emergency?
I'm aware that the fire department, Santa Fe Fire Department, has said that it is not in their mission or not in their goal to provide consistently and for a long term scheduled and interfacility ambulance transportation for the service. They are willing to step up and do the service when needed, and they do that frequently, but they've also said it is not their goal to provide the hospital with an ambulance service that typically transports patients from the hospital to another hospital, from the hospital home, or from the hospital down to Las Cruces or Santa Teresa. So I think your question was, am I aware of information that says that they are not, or they want to reduce the number of interfacility, or part of your question was, so my answer would be yes to part of the question. Santa Fe Fire Department has no intention of reducing the ambulance transport capacity that they do for the 911 emergency system. They would like to stop having to send an ambulance to pick up a patient at St. Vincent's to take them to Albuquerque or to a nursing home or back home.
Is that a recent change in their position?
Well, define recent.
Since the filing of the pre-filed testimony by Chief Suber in this case?
Yeah, I believe the change was since then, and I think the wording from what we saw from the Santa Fe Fire Department was there because they did not understand the full scope of the ambulance application.
So as filed, the city of Santa Fe's direct testimony supporting its burden of proof is dated as having been subscribed and sworn to on September 10, 2020. Does that sound right to you?
I don't have it in front of me. I have no reason to doubt that.
Have you met with Chief Suber between that time and now to discuss what the fire department wants to do?
I have not.
Have you met with anybody else in a management position at the Santa Fe Fire Department between that time and now to discuss what the fire department wants to do?
I have not.
Are you aware of any written description that the fire department has released from that time till now that describes the change in position that you've testified to?
Yeah, I think I would point to the settlement agreement, which you all have all now seen, that clearly delineates what the fire department intends to do and not intends to do and does not intend to do.
Well, there is some ambiguity in terms of what Chief Suber's testimony actually says about what it is doing and what it might want to do in the future, because it does speak about them responding on an emergency basis to transport a patient from Christus St. Vincent to a facility in Albuquerque, for instance. And they have provided some overall figures for how many times they transport patients, but they're not broken down by emergency versus non-emergency.
What's the question, Mr. Bartel? I'm not following.
I'm sorry.
I wasn't following. I couldn't figure out what your question was. What's going to be?
My question for this witness is, do you have any better understanding from Christus as to what percentage of the calls that Santa Fe Fire Department has been handling for them are emergency versus non-emergency?
I don't have a percentage of the calls now. Imagine, I can speculate if you'd like, but no, I don't have a percentage.
I'm not asking you to speculate. I just wanted to know if you'd received any information from Christus St. Vincent. In the request for proposals, did Christus offer to direct any kind of guaranteed call volume to the successful proposer?
No, they did not.
Was there any discussion in their RFP about a subsidy?
No, there was not.
Did you know that Albuquerque Ambulance Service was not invited to respond to this RFP?
I did not.
Have you learned since it was released any reason for why that might have been?
No, I have not. I mean, I think it makes a lot of sense. And again, I can speculate as to why not, but I did not know that.
So it's true that in this proceeding, AMR is not able to offer any information about calls that were made by Christus to Albuquerque Ambulance Service for interfacility transport service after March 20, 2019, which AAS declined.
No, I'm not in a position. I have nothing that shows, again, your question is complicated or complex, right? The ask was, does AMR have anything that shows any calls from Christus to AAS after March of 2019?
That AAS declined.
That I do not know.
Okay, and you also are unable to provide any information about calls by Christus to Albuquerque Ambulance Service for interfacility transport service after March 20, 2019, which Albuquerque Ambulance Service was unable to perform within the agreed time.
Mr. Bartel, I represent AMR, not AAS or Christus. How would I have any of that information?
It's not your
Well,
place to answer the question, but you could say you don't have an answer because you
Okay.
don't know. There hasn't been any objection, but from the bench, I'm going to ask Mr. Bartel to maybe break down your questions a little bit more so I can follow them a little more easily. And this witness really, I don't see how he could possibly know the answers to these questions. I understand you're trying to make part of your case through this witness, but that doesn't always work as well as we might hope.
now in your direct testimony at page 5, starting at line 6, you speak about having a conversation with Christus about how AMR could help Christus. And then you state, quote, Christus described many years of inadequate service or levels of service by Rocky Mountain EMS and Superior Ambulance in Santa Fe, end quote. Is that an accurate report of what Christus described when AMR met with Christus?
Yes.
And did Christus provide any information as to why it had no information about inadequate service by Albuquerque Ambulance Service?
They did not provide me information about why they had inadequate service from AAS. They talked at length about the inadequate service that they have been experiencing for many years, that they are continually kind of at a standstill with requests to, I think even what we are all seeing in this case, in that when we try to ask for data to support that, the current providers don't have the data to show, right? So if you can measure it, you can manage it type of thing. And instead of trying to measure and manage it, they opt just not to measure it. So it's advantageous to not provide data that shows that there are long delays. What I know is the representatives of Christus St. Vincent's explained that this is a common occurrence that has been going on for many years, that they have asked the providers to increase the number of ambulance, or at least voiced their concerns with the availability or lack thereof of ambulance services, and finally got to the point where they invited not only AMR, but all other ambulance providers to bid on a proposal to support their need.
But the report that you have included in your direct testimony doesn't say anything about Albuquerque Ambulance Service, does it?
Again, I'm just trying to answer your question. My report speaks for itself. There's nothing in there about Albuquerque Ambulance. I am not the Albuquerque Ambulance representative.
So Christus told AMR it had gotten bad service, inadequate service from Rocky Mountain EMS and Superior, but did not say it had gotten inadequate service from Albuquerque Ambulance Service. Isn't that right?
That is true, yes. It did not say that.
Now, further down on this same page, page 5 of your testimony, you, starting at line 18, talk about the circumstance when Presbyterian opened the Santa Fe Medical Center in Santa Fe. And my reading is you're making the comparison to that situation and Albuquerque Ambulance Service obtaining authority to this current situation where AMR is looking to support Christus. Is that an accurate summary of what you're stating there in your testimony?
Yeah, I believe that paragraph really is trying to illustrate that essentially one hospital opened its doors in Santa Fe and also was concerned, and however you phrase those, with the adequacy of ambulance services, either the increased demand or the current levels, that they opted to bring in their own ambulance service. And that has worked very well, I imagine, for Presbyterian and Albuquerque Ambulance. And Christus St. Vincent's is looking to do almost exactly the same thing, minus they don't have their own ambulance company.
But isn't it true that when a new hospital opens, there's also going to be an increase overall in call volume associated with the opening of the new hospital?
I would imagine that, yes, that's absolutely true. And I would imagine also that the initial step would be to allow the current providers, in this case, it would have been Rocky Mountain and Superior, to increase their staffing levels to support that need. As an ambulance operator, had I been in Santa Fe at the time, I absolutely would have welcomed the addition or the opening of another hospital because it represents additional transports, which, as we all know, represent additional revenue for the services, and services need the revenue.
And so the commission's determination in Albuquerque Ambulance Services application had to do with whether or not the incumbents who were already working in Santa Fe County could expand adequately to cover the anticipated new call volume. That is not the situation today with Christus St. Vincent, is it?
No, I believe that in part it is exactly the same scenario, right? So we are talking about Rocky Mountain again being suspended, or whatever the terminology is. We know that they are not in business and not operating in the now or in the foreseeable future. So there is an increased suddenly call volume that is unexpected or new to the system. So in some ways, it's exactly the same as Presbyterian opening a new facility in Santa Fe a year ago or 2 years ago. There's an increased
it's really
need.
not, though, is it, Mr. Graham? Because there is no.
He thinks it is. He just testified that it is. If you're going to ask something else to clarify that, that'd be okay.
But we just, Mr. Graham, we just reviewed that the projections that you used to in your pre-file testimony project 2,000 calls a year is based on the historical record coming out of Christus, and that you had no reason to think that that call volume coming out of Christus was going to increase. So it's not the same situation, is it? The call volume coming out of Christus is remaining flat, setting aside COVID for the moment. I understand that's a distortion.
The volume coming out of Christus is remaining flat. The number of providers has decreased. So it is the same issue. There's a need now, there's services, there are calls now that need to be met with one less provider. And it's factual that that provider, Rocky Mountain Ambulance, was in fact handling the majority of the requests from Christus St. Vincent's.
And you
So
would agree,
it is almost exactly the same issue.
but you would agree that AMR has no information and has presented no information in this proceeding that AAS doesn't have the ability to expand its operations to service Christus and whoever else is being serviced by Rocky Mountain EMS if that becomes necessary.
You asked me if I would agree that AMR does not have information that AAS cannot provide additional, in fact, ambulances?
Mr. Graham, I'm simply asking you to confirm that there's nothing in AMR's application that proves that Albuquerque Ambulance Service does not have the capacity to expand its operations to take on the additional call volume resulting from a cessation of services by Rocky Mountain EMS.
Thank you for clarifying. I understand. No, there is nothing in AMR's application that speaks to AES's abilities.
So continuing on page 5, starting at line 22, you make this statement, quote, speaking of Christus, they should be able to rely on and partner with an ambulance company who can meet their needs and help them to compete in Santa Fe, end quote. So what about this relationship with Christus is going to result in AMR helping Christus compete in Santa Fe?
Well, twofold. Again, it's no secret that Presbyterian and Christus St. Vincent's are two different hospitals competing in the same area. Like any services, they compete for healthcare, they compete for patients, they compete for people to come to their facility.
Thank you. I
Ambulance
was
services,
wondering when that would come out. And who, you know, that seems to be the elephant in the corner of the room that I was waiting to come out through testimony. I mean, one competitor is not going to hire the other competitor to work for them. And I'm just, you know, until I just heard that testimony, I was wondering when I would hear that testimony. Continue, please.
Thank you, sir. So naturally, right, it goes to normal arguments that one hospital, just like I would not ever imagine that Presbyterian would want to contract with AMR because it has ownership and interest in Albuquerque Ambulance to contract with the competing ambulance services. So ambulance services help not only move patients out of the hospital, which in turn helps the hospital continue to run efficiently and effectively by opening new beds, but additionally, oftentimes we help with supporting the inbound patient transports coming into them. So it naturally makes sense for any facility, any hospital, to want to have a good partnership in ambulance in other areas of healthcare to provide those levels of services consistently and effectively in line with their strategic mission statements.
So if I understand what you're saying, Christus told AMR that it simply didn't want to use Albuquerque Ambulance Service because it views Albuquerque Ambulance Service as a competitor. Is that correct?
No, Christus did not tell us that it did not want to use Albuquerque Ambulance Service.
Well, did Christus give you any reason to think that Albuquerque Ambulance Service wouldn't provide excellent, timely, clinically correct service to Christus if called upon?
No, I imagine that if they were called upon, AES could provide service when they're free and available. I imagine that the ambulances that Presbyterian has in Santa Fe don't just sit around doing nothing. I think that they are busy also. I think that they're scheduled. They do interfacility transfers, as we know, for Presbyterian. So this assumption that they're just there waiting for a call, I think is inaccurate. They are also transporting patients, and I imagine that if Christus called them, if they were available, they would be glad to handle and help as they have. But that in of itself does not meet their overall goal and objective. It does not meet the need for additional transportation services, ambulance transportation services in Santa Fe.
And so, I mean, it seems, Mr. Graham, that you're saying two inconsistent things. You're saying that if Christus called Albuquerque Ambulance Service, you have no reason to think they wouldn't get good service, but the ability to call Albuquerque Ambulance Service doesn't satisfy the need. Is that what you're saying?
No, you're miscategorizing it again because it serves your interest. I'm saying that Albuquerque Ambulance clearly has a service in Santa Fe. And if Christus needed to and has done, they could call Albuquerque Ambulance. And if those ambulances or ambulance is not busy or otherwise occupied serving the needs of Presbyterian, I imagine, yes, they would be willing to go help. I have no reason to doubt that that service would be professional, it would be adequate, it would be good, solid clinical services. The point is, I believe that Christus doesn't want to rely as a long-term strategy on Albuquerque Ambulance providing them ambulance services.
Did Christus tell you that they thought that if they called Albuquerque Ambulance Service for help in Santa Fe, that Albuquerque Ambulance Service would give them second priority and would take care of Presbyterian patients first, or some kind of problem like that?
I think they told me that that is their assumption, yes. And maybe that's just me, assumptions are wrong. That's their understanding. And I think it makes natural sense, right? Albuquerque Ambulance, again, is owned by Presbyterian, has been well established. If Presbyterian needs to move a patient and Christus needs to move a patient, I think it's pretty clear as to which would get priority. It just makes sense for them. So I think it's their understanding. And then I think there's also been some historical issues that have gone on with Presbyterian that have made them feel like it just isn't a service that they can, on the long term, rely on, right? There's this anecdotal information that runs around about Presbyterian will take a patient, but only if that patient is going back to a Presbyterian facility. Now, I can't imagine that to be true, but those are the sort of things that the area is dealing with that are simply solved with another provider, another ambulance provider.
And you would agree that what you just recited is not based on any evidence in this record?
No, I would not agree with that.
You haven't
What
provided.
I just recited.
You haven't provided any documentation or testimony of any witness who has said that Albuquerque Ambulance Service won't transport unless the patient's going to a Presbyterian facility, have you?
I even prefaced that, Mr. Bartel, to say, albeit it's anecdotal, it's what their perception is. But I would say, no, I do not agree with that. We have provided and will provide and will show that Christus has demonstrated that there is an ongoing need for additional ambulance services.
In your direct testimony at page 7, I believe it's line 16. Well, it starts on line 15. You're asked the question, what's AMR's projected revenue for Santa Fe County? And the answer is $800,000. Do you see that?
I see that.
So is that $800,000 figure, is that before or after the application of the collection rate of 44%?
That's before.
So the net projected revenue based on 2,000 transports annually would be 352,000. Is that correct?
If you did the 44% of that, then yes.
All right, I'll pass the witness.
Okay, let's see who, Mr. Mauer, are you ready now?
Yes, sir.
All right, let's go.
Thank you for your patience. Mr. Graham, this is Fred Mauer. Can you hear me?
I can hear you, Mr. Mauer, and it's good to see you.
Good to see you, sir, and I hope you're staying safe. Mr. Graham, I want to make sure I understand. Mr. Bartel spent quite a bit of time talking about your pre-filed testimony, especially page 5, and the comment you made about lack of service by Rocky Mountain and Superior. That's on lines basically 9 through 11. Do you have any documentation provided by St. Vincent's showing the last time Superior was called by St. Vincent's and what the response was?
I do not have any documentation that shows the last time they were called. No, sir.
Do you know how many times, as an example, in 2020 to date, that St. Vincent's has called Superior and asked them to provide service?
I do not.
And let's do 2019 as an example. Do you have any data that shows how many times Superior was called by St. Vincent's and requested to provide service?
Aside from, I think, the direct testimony or maybe one of the responses for interrogatories from Mr. Chris Archuleta, which I think there is some information in those for at least 2019 and maybe 2020. Otherwise, no.
Okay. So with regard to any allegation with concerning adequate service by Superior, you don't have any personal knowledge of that claim, do you?
No, I do have personal knowledge of the claim. Yes, sir.
Okay, yes, but you don't have any personal knowledge as to calls made and delays that actually occurred. A specific call.
Originally, I believe your question was, do I have the specific numbers or the last time that they called Superior, to which I don't. Personal knowledge, I would say, yes, I absolutely do. I've met with representatives of Christus St. Vincent's, as described in my direct testimony, and they have described the just the issues, the struggles, and really just the course of actions of typically what happens when they call Superior Ambulance Service.
Then please give me an example, time, date, when a call was made to Superior in 2020 and there was difficulty in providing transportation services.
Again, I don't have a time or date because, again, the system is not set up to capture that. And that's also part of the overall need and part of what we want to demonstrate should be available to any party who wants to look at that information. We can't get that information. I'm sorry.
I'm sorry, I interrupted you. I thought you were done.
Oh, I'm just trying to fully answer your question as to why we don't have those specifics. And the answer is we don't have them because the current providers, particularly Superior and Rocky Mountain, don't track that information. Now, why they don't track that information is anybody's guess. What we can say is it should be tracked. There absolutely should be the data papers that show what the average response time is, what the typical response time is, any responses that took more than 1 or 2 or 3 hours after the time that Christus asked for the pickup to occur, but they don't track that information.
Who is the witness that you spoke to at St. Vincent's that gave you the basis of your statement on page 5 about Superior? Which specific person did you talk to?
Mr. Maurer, I'd say that this was in the course of a meeting with multiple people in the room, and that was the general sentiment of Christus St. Vincent's.
Okay, so you can't identify a specific person that I can ask about their experiences?
We could, yeah, but that hasn't been asked for.
Who would that be?
Gosh, Mr. Maurer, I'd have to go back to look at notes. I don't know these folks individually.
All right, so as you sit here today, you can't give me a specific person to ask these questions of, correct?
No, I can't.
Okay, thank you. Now, with regard to then the transportation services being proposed by AMR, it's true, isn't it, that you can't testify today that Superior Ambulance doesn't have sufficient equipment to meet the kinds of needs you've been discussing, can you?
I don't know whether or not Superior has the specific equipment. I have no idea what the quantities of equipment that Superior Ambulance may or may not have. What I do know is that this has been an ongoing issue for many years for Christus St. Vincent's. They have had conversations with Rocky Mountain and Superior, is my understanding. And at this point now have resorted to, in fact, really just feeling like they're not going to get a specific or an improvement in the level of services from either of them.
Okay, and once again, you've already answered my question about who specifically said that comment, correct?
Yeah, I would say it was a generality of everybody that was in the meeting that day.
All right, and who else participated in this RFP? What other carriers?
Again, I could speculate. I don't know.
Okay.
I've learned that Albuquerque Ambulance did not. I imagined, would you like me to give you what I assume?
No, not speculate. I'm talking about what you specifically know.
I do not know who else applied or responded.
Okay. And so if there were other carriers, and I think you said there were other carriers, you don't know what conversations have been held between those carriers and St. Vincent's, do you?
With regard to the request for proposal they submitted?
Correct.
No, I do not.
And you also don't know what was discussed with any other carriers who participated in this RFP process with St. Vincent's, what was discussed between the two of them and the availability of equipment by other parties participating, do you?
I do not.
Okay.
That was close to testifying, Mr. Maurer. Doesn't impress me too much when the council testifies in a question.
And other than what has been testified, what has been stated here today with regard to interfacility transportation by Santa Fe, the City of Santa Fe Fire Department, do you have any other information available than what you've testified to about their position today, besides this agreement?
I'm sorry, Mr. Maurer. It was, again, I think a complex question and you broke up in the middle. Can you repeat it for me?
Yeah, I'm sorry. With regard to the testimony today and the agreement, which has been forwarded by Ms. Majori concerning City of Santa Fe and St. Vincent's, it's true, you don't have any other testimony or information to provide concerning the position of the City of Santa Fe and the fire department, correct?
Object. I think I heard that there was an agreement between the fire department and Christus.
Yeah, could you restate it, please, one more time? Sustained.
With respect to the agreement which has been provided here today and discussed, it's true, isn't it, that you do not have any other specific testimony that would support the lack of equipment being provided by Superior to St. Vincent's concerning that agreement? True?
I think the question changed, but to answer the question that you just asked, again, I don't know Superior's ability to provide additional ambulances. No. But I believe you were originally asking me about Santa Fe Fire.
He asked if you had any other testimony. So did you mean some sort of transcript, written testimony that this gentleman might have?
Anything, documentation or testimony from a witness, anything. And I think he's answered my question. Now, Mr. Graham, with respect to then the presence of AMR in the City of Santa Fe, is it the intent of AMR to enter into a contract with St. Vincent's to provide this service?
No, as it relates to this, our intention is to get a certificate of necessity for ambulance transportation in Santa Fe.
Okay, but my question is it the intent of AMR to enter into a contract with St. Vincent's to provide motor vehicle service?
Well, was that an objection or can
That's
I
an
answer?
objection because I don't know what motor vehicle service is.
By the way,
Ambulance service.
Objection. I presumed he was referring to ambulance service, so I'm not concerned about the word motor vehicle service. Do you mean ambulance service, right, Mr. Maurer?
Yes, sir.
Okay, and by the way, Ms. Maggiore, I don't know what it was. Maybe you were muted at the time, but I didn't hear an objection. So just we'll keep an eye on that in case you're objecting and I don't hear it.
Yeah,
Go
I'm
ahead.
off mute, so we should be okay.
So the answer to the question is, again, we're seeking a certificate for ambulance authority in Santa Fe. We also have what's the word? Not conversely, but we've also clearly won an RFP, again, if that's possible to win an RFP with Christus St. Vincent. So if we were to get a certificate for Santa Fe, yes, I imagine we would enter into a contract with Christus St. Vincent's for ambulance services.
And would that contract that you're discussing be for exclusive services? In other words, they would only use you,
No, I
meaning
don't.
AMR?
No, Christus would, I don't think that it means that Christus would only use AMR.
Okay. Okay, I have no further questions. Thank you, sir. It's good to see you again.
You too, sir.
Thank you, Mr. Maurer. Okay. Salazar is not here. We got Mr. Padilla. Mr. Padilla, ready to examine, or would you guys like to take a break? It's 1:30. I think it's a good time for a break, and we could take an hour. Is there any comments on that?
That's good with me.
Okay, I don't hear anybody objecting very loudly. Let's take a break and reconvene at 2:30. Thank you, everyone.
Thank you.
Thank you.
Thank you.
Allison, hi. We can see off the record for a couple minutes or so. Ms. Maggiore, did your witness return, Mr. Graham? There he is.
I'm here. Thank you.
Oh, okay, nice. We're still off the record. Let's see, we have everyone. We have Chris Archuleta on. We have the telephone. Mr. Montoya is back. Chris Ryan, I think, is there. Are we missing anybody? Mr. Maurer, I see the top of your head there on the corner. And there's Mr. Padilla. I notice your client is not there. Is he coming back? Okay, there he is. All right, if we have all the cast of characters, there's no reason for any delay. Are we all ready to go? Okay. All right, Ms. Hoyman, back on the record. Thank you, everyone. I hope your lunch was fine. It's now 2:32. We took an hour off for a lunch break. We were in the middle of the examination by interveners of the AMR witness, Mr. Graham. Mr. Bartell had already examined him, and as did Mr. Maurer, and I think we were going to move on to Mr. Padilla. Mr. Padilla, are you ready, sir?
Yes, sir.
All right, please proceed. You're still under oath, sir.
Understood.
Good afternoon, Mr. Graham.
Good afternoon.
My name's Ray Padilla. I'm the attorney for Rocky Mountain EMS. I'm going to go, first of all, through questions that I have with regard to your pre-file testimony, and then I'll move on to some follow-up stuff that I have for questions that other people had. So do you have your pre-file testimony with you there?
I do.
Okay. Let's just start on page 2, sir. You're at line 7, you say you're the regional director for AMR, correct?
Correct.
Can you tell us what that means? What are your responsibilities and what regions do you, or if that's an appropriate term, what areas are you a director over?
Well, I'll start with, generally speaking, I oversee the ambulance operations and really the air ambulance operations in some areas, and we'll go into that here in a second. Each of the operations generally has a local person who we title typically the operations manager or the administrative supervisor, who oversees directly those operations, and those folks report up to me. I work with them on kind of annual strategic plans, growth opportunities, compliance with rules and regulations, recruitment, retention, budgeting, all of those sort of things. The region that I work for or work in is New Mexico, and I am the director of both ground and air operations that Global Medical Response has in New Mexico.
Do the ground and air operations interact?
Well, occasionally, sure. Like as an example, some of the air operations fly into Albuquerque, and our AMR ground team will pick them up at the airport in Albuquerque, transport them to the hospital and back.
Does it work the other way around? For example, the ground people don't have an ambulance, a ground transport available to transport a particular patient, so they contact the air transport and substitute the air transport for ground?
No. From a GMR perspective, our EMTs and paramedics on the ground ambulance don't just get on an aircraft and transport a patient.
No, I'm not talking about somebody from an ambulance getting on an aircraft. I'm talking about a ground transport ambulance not being available. So as an alternative, the ground transport people or perhaps dispatch contacts the air component and says, we don't have a ground unit, so let's take them by air.
No, the decision to move patients like that is made by the hospitals and generally by a physician, right? EMTs and paramedics don't have the authority to just say, hey, we're not available for a ground ambulance, so we're going to, in fact, use an air ambulance. Again, those would be decisions that the hospital and the physician would make. In some very rare circumstances, for our example, right, we have, like in Gallup, New Mexico, there is a ground operation, a GMR ground operation, and a GMR area operation that has a helicopter. Those helicopters respond to 911 calls and transport directly from the scene whenever the patient criteria meets established parameters. But in those circumstances also, there's a ground ambulance on site making the determination that the patient needs to move quickly via helicopter to a hospital.
So what would happen if AMR is requested to provide a ground transport, and at that point in time, there is not an ambulance available to provide that ground transport?
We would look for another provider or somebody to help us in a mutual aid situation.
And with regard to mutual aid, do you have specific mutual aid agreements in every county in which AMR operates, or do you simply rely upon the statute making reference to mutual aid and contact somebody else?
No, it's my belief that we have mutual aid agreements signed with other providers who are or happen to work in and around the areas that AMR has an operation.
When you say other providers, are you talking about all providers or just select ones?
Again, you'd have to give me an example of an area that you're talking about. But typically we have a mutual aid agreement with any other provider that has an ambulance, right? So in the ambulance world, I don't have a mutual aid agreement with the fire department that doesn't have an ambulance because they can't provide ambulance services.
Okay, so translating that to what we have before the hearing examiner here today, if AMR is granted authority, then would AMR automatically attempt to enter into a mutual aid agreement with Albuquerque Ambulance Service?
Are you talking about in Santa Fe if AMR were to get in?
I'm talking about if you're to get into mutual aid agreements with people with ambulance services which have ground transport. Right. I'm asking if the plan is to, as part of getting into Santa Fe, would you enter into a mutual aid agreement with Albuquerque Ambulance?
Yes, I assume so. We would definitely ask to, right? And I think there's a PRC regulation that says that the provider should or shall have I'm not sure exactly how it's worded. It's never been an issue, but yes, we would definitely ask to enter into a mutual aid agreement with all of the providers who are currently certificated in Santa Fe.
So that would be Albuquerque Ambulance. I presume it would include Superior?
Yes.
How about Rocky Mountain?
Well, again, right now, as I understand it, they're not in business and they're not operating, and it would be a violation of them to provide a mutual aid assistance for any service. But again, assuming that we're talking about 6 months ago, or in the future, should they have their certificate reinstated, or if they're back in business, however the fashion is, then yes.
Okay. Do I understand correctly that you would not follow through with a mutual aid agreement for the city of Santa Fe or the county of Santa Fe Fire Department, because that's an EMS situation?
No, I think we would also absolutely try to enter into a mutual aid agreement with them. From our perspective, right, the mutual aid agreement would most likely be in the event of a mass casualty incident, they could then call AMR if needed for assistance. So the mutual aid agreement essentially goes both ways, not just one-sided.
Well, in the event of a mass casualty situation, there really wouldn't be a need for a mutual aid agreement, would there? I mean, the law says if there's an emergency, you've got to respond. well, if you passed by an emergency, you can't reject an emergency, I believe is what the statute says. So if you had a disaster where you know for a fact that there's not sufficient emergency service from either of the fire departments and somebody called you, you wouldn't say I couldn't do it if I don't have a mutual aid agreement, would you?
No, you wouldn't. But the point of pre-planning for mutual aid agreements is that it's inevitable. It's going to happen. We want to have mutual aid agreements in place before it happens so that we could show up and everybody would kind of have a good understanding of how the services are going to interact, whose liability falls under who, and all the sort of things that go into place with dealing with crisis and chaos like that. What you don't want to do is just show up because it happened and then try to deal with all of the issues afterwards. Again, if we don't have a mutual aid with somebody and they request us to show up for a mutual aid, we'll come, but it's better practice to pre-plan and have a mutual aid agreement in place.
It was just so that I understand what type of mutual aid agreements AMR typically uses and would rely on. Can you, and so that it's clear on the record what mutual aid agreements actually means, can you tell us what the components of a typical mutual aid agreement that AMR enters into are?
Well, that's a broad question, but generally speaking, they say if you need ambulance services that we don't typically provide, we will call you and you could call us, conversely.
What do you mean that we don't typically provide?
So again, in Santa Fe, as an example, if we're not providing 911 services and there's a mass casualty incident, which would be typically a 911 issue, we would have a mutual aid agreement in place that says in the event that you decide that you need additional ambulance support, we're here, we can help. And we've got entered into agreements that show how we're going to respond.
Well, what about mutual aid agreements then with somebody who provides the same service that you do? For example, Albuquerque Ambulance provides ground transport just like you do, and you've already said you would enter into mutual aid agreement with Albuquerque Ambulance. So don't you and Albuquerque Ambulance typically provide the same service?
Yes. In this instance in Santa Fe, right, we would provide a very similar service to what Albuquerque Ambulance is providing for Presbyterian.
Okay, so you said earlier, typically provide, and you explained that would pertain to emergency services. When you enter into a mutual aid agreement with somebody like Albuquerque Ambulance or Superior or even Rocky Mountain, what would be contained in that? What's the point of having the mutual aid agreement?
Well, again, it pre-plans and formalizes what responses are going to look like, who's going to share liability, or that essentially each individual operation is going to assume the liability of the response. Again, a mass casualty or a mutual aid agreement, try to be a big umbrella for lots of different issues, right? Including potentially that there is an event at Presbyterian or Christus St. Vincent's or a local nursing home that means that they've got to move 20, 30 people as quickly as possible. Mutual aid agreements essentially spell out that one ambulance service agrees that they'll go help another ambulance service if requested to do so.
Okay, now you've said a couple of times, you've used the phrase, who's going to have financial responsibility. Does that mean if you are acting under a mutual aid agreement and you transport a person at the request of somebody like Albuquerque Ambulance, that your insurance takes care of it as opposed to Albuquerque Ambulance? Is that what you're talking about, or is it something more than that?
Well, financial responsibility is a couple of things, right? And it depends on really who's asking it. So financial responsibility could be insurance, right? And making sure that folks are covered on insurance and liability insurance. Could also be with regard to who's going to bill which patients and how. So typically mutual aid agreements spell out that if AMR responds under a mutual aid request with somebody else, that in the event that we should get into an accident, either en route to or dealing with in some form or fashion a part of that mutual aid response or mass casualty incident, we would go through our normal processes and not try to go after the requesting agency's insurance to cover our liability or vehicle collision or whatever. Additionally, typically they spell out that would say AMR in this example will bill whatever patient they transport under their normal billing procedures and not expect that Albuquerque Ambulance or Superior or Santa Fe Fire is going to be financially responsible for the patient that we transport.
Okay, and would the agreement with regard to billing also clarify that whatever billing there was, whatever was paid would go strictly to AMR as opposed to, say, Albuquerque Ambulance or somebody else getting a portion because they brought you into the circumstance? Is that clear or not? You're looking like you don't understand.
No. I don't know that I fully understand what you're asking me, no, sir.
Okay, let me see if I can be a little more clear. You have a mutual aid agreement with Albuquerque Ambulance, just for an example.
Okay.
And Albuquerque Ambulance says, we can't take this call. Would you please take it? And you say yes.
Okay.
Then you bill for the call, whatever the amount is. Does the entire amount of the billing go into the pocket or into the bank accounts of AMR, or does the mutual aid agreement have some sort of provision that says because Albuquerque Ambulance in this example called you, you give Albuquerque Ambulance 10% of what you collect, something like that?
Okay, thank you. I understand. No, typically in my experience, and I can only answer from my experience, in my experience, the mutual aid agreement spells out that AMR in this example would bill the patient and collect whatever we're going to collect from either the patient, Medicare, Medicaid, their private insurance, and there is no sharing of that revenue with the other service who called. But that should not be said as that's exclusively how they work. That's in my experience.
Okay, and the billing then I take it would be under the tariff of AMR in this case, even if Albuquerque Ambulance might have a different tariff, correct?
That's correct. And that's generally another part of the mutual aid agreement to say, if in the event that we respond, we're going to bill under our normal tariff rates, not the other person's or the other entities.
So depending on what the tariffs for the two ambulance services are, the patient could potentially be billed more, could potentially be billed less, or could be billed exactly the same. Would that be fair?
That's fair.
Okay. Now, as the regional director, you talked about, or in your testimony, and I think in the certificate that I've seen in this particular case, AMR has authority currently in Valencia County, in Bernalillo County, and in Curry County. Would that be correct?
That's correct.
Okay, but I don't know whether this is a sister organization or whatever, but there's also services being provided in Doña Ana County and Otero County. Would that be correct?
That's correct also, yes, sir.
Okay, so 5 counties total so far?
That AMR operates in, yes.
Okay. And do all 5 of those counties have the air service available as well as the ground service?
No. I mean, the simple answer, I think, is no. If you're asking me, do we have an air ambulance component in each of those 5 counties? The answer is no.
Okay, so would it be fair to say that you have an air ambulance component so you could make that air ambulance available if necessary in any of those 5 counties?
No, not necessarily. Again, Mr. Padilla, if I'm understand your question, air ambulance is again a broad term. And so if you're asking, could I make an air ambulance available in any of those 5 counties? The answer is no, I couldn't.
And does that have to do? Go ahead. You were going to say something else. I didn't mean to interrupt you.
I said I'd like to have the ability to, but I don't.
Okay. How did it come about that AMR is also providing the services in Doña Ana County and Otero County?
What do you mean, how did it come about?
Well, you've got a certificate in this particular case that deals with 3 counties, Valencia County, Curry County, and Bernalillo County. Okay. But you also, in your direct testimony, say that AMR is operating in Doña Ana County and in Otero County. Since it's not on your certificate, I want to know how that comes about. What's your authority for that?
I see. I'm going to try to answer your question. So in Otero County and Doña Ana County, AMR leases the certificate of necessity and the authority to operate an ambulance service from those counties respectively, right? We don't own the certificate for Doña Ana County or Otero County. We lease it under contract from those counties. In the 3 other counties that you've mentioned, Valencia, Bernalillo, and Curry, AMR owns the operating authority or the certificate of necessity and has the operating authority for those counties.
Now, does AMR, well, how many ambulances does AMR have available in the state of New Mexico total?
How many ambulances total do we have? The answer is roughly 60.
Okay. And is there any back and forth with those ambulances? Let's say, for example, you need extra ambulances in Valencia County at a given point in time. Do you take ambulances from your Bernalillo County operation and move them down to Valencia?
Yes, but in Bernalillo and Valencia, really those 2 operations, because of the proximity, really kind of work conjunctively to serve both of those areas. So in those operations, right, we do use ambulances in Bernalillo County to respond in Valencia County. But again, that is strictly due to the proximity of Bernalillo County and Valencia County.
Okay, so let's talk something farther away, Bernalillo County versus Doña Ana County. Do you share ambulances that are stationed in Bernalillo County with the needs that might arise in Doña Ana County?
No, typically that's too far away. I don't know if this has happened between Bernalillo and Doña Ana, and I'm offering it to help with maybe what I think your question is. In the event that the Doña Ana operation needed an extra ambulance, the physical ambulance, we could in turn move a truck from Bernalillo to Doña Ana, but we would have to also notify the PRC that we've got an additional truck in that area. And so typically, from my knowledge, we've not just sent an ambulance down there for any length of time without saying, okay, this is now permanently part of your fleet.
If you're granted this authorization, do I understand correctly that the plan is to initially place 2 ambulances in Santa Fe County?
Yes, sir.
And what if there becomes a need for a 3rd ambulance? Would the plan be to go buy a 3rd ambulance, or would you simply supply from Albuquerque because you're only 60 miles away?
Well, it depends, right? I guess it depends on the situation. If we needed to move a truck in there immediately, we would probably just borrow a truck from one of the organizations or one of the operations. I don't know that specifically it would have to be from Bernalillo County, but if one of the trucks had a surplus that they could loan, typically we call those a reserve truck, and it looked like it was going to be a long-term project, and a good vehicle for that area, we could move one to Santa Fe. If it was something else, we would look to buy a vehicle to have it stationed and assigned in Santa Fe.
Does AMR already own and have fully stocked the 2 ambulances that it anticipates will be used in Santa Fe?
Yeah, the part of the application requires that you demonstrate the vehicles, is my understanding. So we have vehicles that are typically or that are currently in reserve status in Bernalillo that we would assign to Santa Fe immediately.
What about personnel?
Again,
Personnel that goes along with those vehicles, or would you have to hire new personnel that's based in Santa Fe?
we would have to hire new personnel that's based in Santa Fe. In the event that the PRC or the process were that we were to be granted authority today, tomorrow, and I know that's not realistic, but just as an expectation or just as an example, excuse me, we could staff it with employees out of Bernalillo County and Valencia County immediately and for the foreseeable future. But our intention, of course, would be to hire employees specifically for that area.
So based upon that answer, would I be correct in concluding then that AMR has not yet taken any actions to hire personnel that would be based in Santa Fe County?
No, you wouldn't be correct. It may be a bit presumptuous on my part, but because I've been kind of pre-planning and optimistic, hoping that we will get this authority, we have essentially been pre-planning. We have currently a bit of a surplus in our staffing levels in Bernalillo and Valencia County. In part, it's been working well because of the increased demand with COVID and the pandemic. But we again could very realistically stand up a truck or two trucks in Santa Fe very close to immediately.
Okay. Now, I want to be clear on exactly what you're asking for here. Because first of all, there's been a settlement with the Santa Fe Fire Department, which seems to have modified what AMR is asking for. Maybe it hasn't. Maybe I'm incorrect. I don't know. But looking at your application itself, and do you have the application available to you?
Yes, sir. Yes, sir.
Okay. If you look at page 9 of your application.
Okay.
It says about the middle of the page, please give a specific description of the services to be provided. You see that?
I see that.
Okay. It says ambulance service from points and places in Santa Fe County, in addition to authority granted by the commission in Curry, Bernalillo, and Valencia counties under certificate number 56829. Is that the scope of what you're looking for, or has that changed somehow or other? And if you need to, you can look at the specifics of your certificate, which is Exhibit A, I think, to your, or it immediately follows the, I don't know if it's marked Exhibit A, but after page 12 of 12, it's the next page.
I'm going to stick on page 9 of 12 and then move down to that if I need to. Otherwise, my brain gets a little foggy.
Let's do 12 and then we'll move on.
Okay. So it does say, please give us a specific description of the services to be provided. Our understanding really, though, is that the PRC recognizes ambulance services, right? And I think then us, the providers, the operators, the different organizations really start to muddy the water with emergent, non-emergent, scheduled, interfacility, all those other things. So when we applied for the certificate, we are under the understanding that we have to apply for an ambulance certificate, right? And an ambulance certificate does both emergent and non-emergent, scheduled and interfacility. And then our operations plan and internal workings with the other providers really starts to spell out how you're going to operate within that area of authority, right? So for us, from my perspective, it hasn't changed at all. I recognize there has been some confusion. I think some of it has been man-made, if you will, in that we like to try to muddy the water in order to make it look like we're doing something, we're not doing something. But again, we're applying for an ambulance certificate with the intention of meeting the need of interfacility services in Santa Fe County. So our application is for an ambulance certificate in Santa Fe. Our intention is to operate interfacility, scheduled and unscheduled ambulance transportation.
So are you asking that when your certificate, if in fact you're allowed to operate in Santa Fe County, when the new certificate is issued, that it specify that intention?
No, we're not. And again, that goes to the point of, we also didn't apply for what we don't believe to exist, an interfacility only ambulance certificate, right? To my knowledge, all ambulance certificates are ambulance certificates to provide ambulance services. And then inherently it's incumbent on that operational organization to work within the framework of that territory and operate the way the business plan models, right? So as an example, at Superior Ambulance, they're have a certificate of need or a certificate of necessity for multiple parts of New Mexico. In some areas, they operate 911 and interfacility. In some areas, they operate strictly as interfacility. But there isn't a specific checkbox, if you will, for a interfacility only ambulance service or a 911 only ambulance service. The PRC simply asks us to apply as an ambulance service.
Are you familiar with the certificate for Superior?
Relatively, yes, sir.
Okay, well, doesn't the certificate for Superior specifically say excluding certain types of service? In many instances saying excluding 911 service or emergency service in particular areas.
It does, yes.
Okay, so what I'm asking is, I'm asking whether AMR is seeking a general authority to perform all natures, any and all natures of ambulance service in Santa Fe County, or whether you're seeking something more limited to that and you want your ultimate approval, if it's granted, to show that the authority is more limited than overall authority.
Mr. Padilla, I feel like I've answered your question. We're applying for an ambulance certificate for Santa Fe County with the intention of operating where the need is, and that is interfacility scheduled ambulance work.
As the regional director for AMR, are you required to be familiar with the statutes that govern the operation of the ambulance service?
Generally, yes. We also include that no one individual is going to be the sole and only expert. We employ attorneys, compliance lawyers. I mean, just generally the regulations, I guess, that you cite could be Medicare, CMS, in which I would say, no, I'm not an expert. Again, there I have a general idea of what those regulations say. But
okay, you have a general idea about regulations. Do you have a general idea about what the statutes say?
I believe so, yeah.
Well, let me be more specific. The existing certificate that accompanies your application, AMR's application, says the description of the authority is a certificate of public convenience and necessity to provide ambulance service as defined by the Ambulance Standards Act, the New Mexico Motor Carrier Act, and the Motor Carrier Rules. So you're talking about two statutory provisions and one rules provision, and it's generalized as providing ambulance service. So do you know, first of all, what the definition of ambulance service under the Ambulance Standards Act is?
Again, yeah, I would say generally, yes.
Okay, what's your understanding of the general description of or definition of ambulance service under the Ambulance Standards Act?
It goes on to define essentially what a makeup of an ambulance is, how ambulance services are to staff and respond, and then also I imagine if I'm thinking of the right thing, spells out some general rules for safety equipment that ambulances will be equipped with and follow.
Okay, I think you misunderstood my question, sir. I'm asking for just the definition of the phrase ambulance service. If you know how the phrase ambulance service is defined under the Ambulance Standards Act.
I do not.
Okay. Do you know if there's a definition for ambulance service under the Motor Carrier Act? And if you do you know what the definition is?
I think there is a definition for ambulance service under the Motor Carrier Act. I couldn't recite that to you verbatim. I would turn to my handy book.
Okay. And do you know whether there's any definition for ambulance service in the rules, the motor carrier rules of the PRC?
Yes, I believe there's a definition of an ambulance service in the motor carrier rules from the PRC.
Do you know whether that definition would be identical to the definition in the Motor Carrier Act, or whether there's any difference?
I don't know. I imagine they're very similar.
Okay, let me go on then. This talks about, I read to you about the Ambulance Standards Act, New Mexico Motor Carrier Act, and the Motor Carrier Rules. And then it goes on to say transporting patients and or deceased persons from points and places. And then in your current authority, it makes reference to Valencia County, Bernalillo County, and Curry County. What are you asking in your authority to operate in Santa Fe County to be able to transport deceased persons?
No.
Okay. Do you, in any of the other 5 counties that we've talked about, the 3 that are included in the certificate plus Doña Ana County and Otero County, does AMR transport deceased persons?
No.
Does AMR have any intent to transport deceased persons?
No.
Do you have any, this is a certificate that was issued on the 19th day of December of 2019, and you've been the regional director since February of 2015. Do you know why there's a provision for AMR apparently being able to transport deceased persons?
I believe that that deceased person's language is just a historical thing that's been in certificates for as long as I can recall looking at certificates in New Mexico.
Would you agree I'm sorry, go ahead.
I was going to say, I imagine at some point it was common, or maybe not uncommon, for ambulance services to be relied on to transport deceased persons to funeral homes and but that's not what we typically do anymore.
Would you agree that it would be best to have an authorization that is specific to what you described as what AMR intends to do in its operation in Santa Fe County?
Would I agree to that? No.
Why not?
Because I think that,
for example, to do emergency service, why would you want a certificate issued that, at least from a technical standpoint, authorizes you to do emergency service?
Because I think that ambulance services provide a specific scope of work, right? And that is transporting people who need medical assistance and transportation. And I don't think that it should be carved out to say, in this circumstance, an ambulance provider is authorized to only do this type of work. And in this circumstance, they're authorized to only do this type of work.
If the PRC chose to put limitations on the type of work that AMR would be doing in Santa Fe County, for example, excluding 911 transports and limiting transports to strictly interfacility transports, would AMR accept that or not?
Well, yeah, sure. If the PRC chose to do that, then we of course would accept that.
Now, you're talking about, or you're requesting not only authority to operate in Santa Fe County, but you're requesting authority to station in Santa Fe County, correct?
That's correct.
What is your understanding of what stationing entails?
I'll tell you what my definition of stationing entails, right? And I think you asked it differently, but I'll tell you my definition of stationing means that the ambulance provider has ambulances stationed and staff assigned to that station in that particular territory. In this example, Santa Fe County. I know that Albuquerque Ambulance and Superior both, have the, I'll call it, quote, statewide ambulance authority, but in many circumstances, they don't have the stationing authority to station an ambulance there. So that's to say, as Albuquerque Ambulance, as an example, has the authority to go to Carlsbad, New Mexico, and pick up a patient and transport them somewhere else in the state of New Mexico, but they don't have the authority to station ambulances in Carlsbad, New Mexico. So we're asking for authority to pick up patients in Santa Fe County and station our ambulances in Santa Fe County.
Okay. So is the authority to pick up that is being requested solely limited to Santa Fe County?
Is our application?
Yes, I'm talking about picking up patients, not where they're dropped off.
Yes, this application is asking for an amendment to allow us stationing and pickup authority in Santa Fe County.
Now, the stationing, if I understand it correctly, is actually, at least initially, stationing on the grounds of Christus St. Vincent Hospital, correct?
That's correct. When we met with them, we clearly said, look, we don't have a station here in place. At the time, they were really eager to try to get us in. And again, remember, this was under a different framework almost a year ago. But they even said, look, we'll allow you to station your ambulances here at Christus St. Vincent's. Ultimately, for us, has been asked many times in requests for interrogatories and production. Our intention is not to stay at Christus St. Vincent's. We would enter into a lease agreement in a suitable building in Santa Fe.
Has there been any action taken with regard to exploring the availability of suitable property for lease in Santa Fe that is not on the premises of Christus St. Vincent?
Very preliminarily, again, I tend to be an optimistic person, and so I have, in my trips to Santa Fe, just driven around. But AMR is a big corporation, has been also well documented. We have a team of folks who are involved when we enter into a lease agreement or start to look for potential lease property. So in the event that we were to get a authority for Santa Fe, we would engage that team to help us quickly, effectively, and efficiently get into a lease agreement for a building in Santa Fe. So to answer your question, yes, I've looked around, but that really amounts to nothing else than me kind of driving around, seeing what would be a good location, what the current recommendations are. Are there vacant properties in and around the area? Where are those sort of things, but no discussions with a potential landlord or anything like that.
Do you have any idea, as we sit here today, how long it would take AMR to locate and accomplish the lease of a stationing property in Santa Fe if the commission decides to grant your application?
Well, again, if the commission granted our application, we would immediately park and stage an ambulance at Christus St. Vincent's. Our employees would use the location at Christus St. Vincent's for bathroom, kitchen, facilities, those sort of things. We would also immediately start working on locating a building. In my experience, that typically takes a month or two to find a location and enter into a lease agreement.
And is that what you would expect in Santa Fe, that you could get it done in a month or two?
Yes, sir.
And this stationing that we're talking about at Christus St. Vincent in Santa Fe, did I understand you correctly to say that that was the initial discussion with the hospital that took place about a year ago?
That's correct.
Okay.
Mr. Hearing Officer, I'm going to put an objection on the record so I don't have to interrupt. This is sort of morphed from cross-examination into something more like a deposition or discovery. And we're sort of off the mark on cross-examination of his direct testimony at this point. We're well off of it.
Okay, well, I was waiting for somebody to object for relevancy, but I don't take an active role, and unless I have to. I agree, and it's sustained. Mr. Padilla, I'm hearing questions, they're good questions, but I just can't figure out why they're related to this application right here. Not the most recent questions, but earlier in your interrogation. And I even heard references somewhat veiled to other type of litigation, other type of cases, other parties, recent filings concerning the air transport and all that stuff. I couldn't figure out why you were referring to air transport specifically. So I'm going to ask you to please limit your line of questioning to things which are really apparent to this particular application. Thank you, sir.
With regard to your stationing on the property of Christa St. Vincent, would you be paying rent?
Yes, sir.
Do you have an agreement with Christa St. Vincent that you would pay them rent?
We don't have an agreement that says we would pay them rent, but it's normal course of business. You pay at least fair market value in order to prevent any compliance issues.
What I'm trying to get at, sir, is it seems to me if you're at Christa St. Vincent, that gives you certain advantages over the people who are already authorized to provide ambulance services in Santa Fe County. One of the advantages being that you are right there, so you have priority for your services being used, which, if I understand correctly, might be something Christa St. Vincent wants, but also you could have an advantage in that if you don't have to pay them rent, you have an economic advantage over others. So could you clarify my concerns for me, please?
That wasn't a clear enough question to be answered. I think what he's asking, that was just dictating into the record, almost testifying, and understand your position, Mr. Padilla, and understand your client's position. But he's already answered that he doesn't have a contract with the hospital. So if you want to ask another more specific question, you're welcome to do so.
Well, Mr. Hearing Examiner, part of the burden is to demonstrate that there's no harm to other ambulance services. And what I'm trying to get at is if this particular ambulance service is right there on premises, obviously that's an advantage. It's a detriment to other ambulance services. But from an economic standpoint, if there's no rent to be paid, then that's a very distinct advantage over and above the other ambulance services, because as I understand it, rent is probably calculated into the tariff rates.
Well, and exactly. And his testimony was that rent is to be paid. And there you go. That's it. He's already testified to that.
Okay. Mr. Graham, getting back to your direct testimony, on page 1, well, not necessarily just page 1. Actually, it's on page 2, starting at line 5. You go into quite an explanation of AMR, being part of global medical response, 37,000 employees, hundreds of subsidiaries, all the rest of a bunch of information. What's the purpose in providing that information, which would be essentially from line 5 through line 21 on page 3.
Excuse me, but isn't it obvious it was to answer the question, please describe the nationwide operations of AMR?
It's not obvious to me because at a later point in time, he says, when he talks about projected income and how AMR is going to pay for the operation, going to finance the operation in Santa Fe, he says that the financing is going to come from the billing for the services that are provided. So I'm interested in how this information adds to or provides something that needs to be considered in this particular matter, other than just generalized background, which may or may not be relevant.
All right, what's a fair assessment? Sir, do you understand the question and can you answer? Why'd you provide all this information?
I believe I do, and I can. So we provided it in twofold: A, to answer the question; B, I found particularly in my position in having done this, that there are a couple times where being a big organization is something that most people want to know about, right? And so they inevitably, had we not provided the information, other folks would be examining me on the overall scope and size of AMR and our ability to potentially subsidize one operation from another. So we found that it's easier generally to be open and transparent about the size of organizations, the makeup of our organizations, and then stand for questions on how it works and the different delineations of the organization. So with that in mind, that's what we were hoping to achieve with answering that question and providing that information.
Okay, were you intending to convey with this information about the global medical response and everything that I mentioned, 7,000 ground vehicles, 115 fire vehicles, that would all somehow or other support the certification that AMR is seeking in this case, or was it just background showing where AMR fits in the scheme of its corporate structure?
You're on, Mr. Hearing Officer, I'm going to object again. Part of our burden is to prove that we're fit and able to perform the ambulance services that we have applied for authority for. And I think, as Mr. Graham said, if we didn't put it in there, they'd say, oh, you didn't say anything about being fit and able. So hopefully this will go to that part of our burden.
Thank you, Ms. Majori. I'm going to overrule the objection. It is somewhat in the nature of cross-examination, so I let them have quite a long leash. I just want it to be relevant, and it seems somewhat relevant, so I'm going to overrule respectfully. Go ahead, sir.
Yeah, thank you. So again, sure, it absolutely goes to show our fitness, our ability to bring resources. It is not meant to imply that there will be 37,000 employees in Santa Fe. We're again just being transparent with the size of our organization, the scope of our organization, and our ability to provide the services requested in Santa Fe. Healthcare, as we all know, is local. We are proud of our local operations. We're very proud of the New Mexico operations that we have, probably nobody more so than me as a local New Mexican. But it also is inherent for us to show our overall size and fitness. And again, that paragraph on page 3 from 5 on down is really just a summary of the overall scope of global medical response.
So would it be fair to say that that's not intended to demonstrate the specific resources that are going to be available in Santa Fe?
Ask and answer. That's what he just said.
That's what I was just going to say.
So
page 4 of your direct testimony, sir, line 3 and 4, it says AMR would primarily perform ambulance transport for non-911 related ambulance needs. What do you mean primarily?
That the run-of-the-mill or the typical call will be a non-911 ambulance transportation.
Okay, and then you go on to say, generally speaking, this type of service is a non-scheduled ambulance trip from hospital to hospital for higher level of care, or from hospital to a rehabilitation facility or nursing home. What do you mean by non-scheduled ambulance?
Mr. Padilla, a non-scheduled ambulance would be one that, and I'm not trying to be sarcastic, it is one that is not scheduled. So hospitals sometimes will schedule a trip to say, hey, we'd like you to come pick up a patient at 3 o'clock, right? And you say, okay, great, that's a scheduled transportation. Most of the time in my experience, especially in New Mexico, hospitals call and say, hey, can you come pick up a patient right now, right? We need to move somebody right now or as soon as you can get here. That's typically what we see, and those are unscheduled, right? They don't have a scheduled time.
Okay, and let me explain to you, if I could, maybe why I asked that, because that same phrase, non-scheduled ambulance services, is used quite a bit in the pre-filed testimony with regard to Santa Fe Fire Department, and that pre-filed testimony sort of looks like they're talking about, when they say non-scheduled, that's emergency, that's 911. But when you say non-scheduled, I'm trying to get at whether that's something different. And you've told me it's when an ambulance or when a hospital just calls and says, we've got somebody, are you available to pick them up? But is it anything more than that?
Is non-scheduled anything more than that?
In terms of what you mean in your testimony,
no, again,
it doesn't apply to 911, does it?
No, it does not. So 911 is, that's why we said non-911 related ambulance transportation. And then typically that's non-scheduled interfacility work.
Do you have any idea what percentage of calls AMR would expect to be non-scheduled versus scheduled?
It would be a swag in my, but here I would say 80% to maybe even 90% are likely unscheduled interfacility trips.
And typically speaking, if a hospital calls and says, we've got a patient that we need to have transferred, is there a time frame that would be typical for expected response? Would you
Mr. Hearing Officer, again, we've wandered off the mark from cross-examination on the direct testimony to somewhat of a discovery deposition.
Thank you, Ms. Majority. I do kind of like to hear the end of the question before I hear an objection. You know, we're dealing with Zoom here, and it gets a little bit weird on Zoom, and I know you want to get your objection in, and I know that I want to be able to rule on objection before the witness answers. So it all gets a little bit weird, and so I'd ask you to wait until he finishes asking the question before you object, and then I would also ask this witness and all witnesses, if there, I see we've got a couple of them online here, to wait maybe a second or 2 seconds before they answer, which gives your lawyer time to object and gives me time to rule on the objection. And I didn't find that it was, I didn't find that I was at the point where I could sustain your objection. So perhaps you'll make it again at the end of the question, but it's overruled. Go ahead, Mr. Padilla.
Did you understand the question, sir?
I think I did, but can you rephrase it again or just re-ask it? I lost track of it.
I'm just interested in what if on these non-scheduled transports that you're referring to, is there a general time frame when an ambulance service is expected to respond? Are you expected to be there in 10 minutes, in an hour? How long?
Typically,
Same
it's
objection.
Okay, sustained. Mr. Padilla, could you help me to understand why that would be important in general? As you asked the question in general, why would that be important for this application to expand the certificate into Santa Fe County?
Because it's a question of the effect on other ambulance services. If this ambulance service is on site and it can respond within 2 to 3 minutes, as opposed to another ambulance service, which might take a half an hour or an hour to respond, then this ambulance service has a direct advantage over others. And the statute, in my opinion, in certain respects, requires the commission to protect the interests that already existing approved ambulance services in Santa Fe County have.
And the public as well, am I correct?
Yes, sir.
Well, in that case, I'll let you continue asking that question because I think it's relevant to protecting the public, that we know how long it takes for an ambulance to respond. Sir, if you've already began your response, you can continue, please.
Thank you, sir. Mr. Padilla asked me what the typical response is for a non-scheduled interfacility ambulance transport. Ultimately, that's a customer's expectation, right? And in this example, Christus St. Vincent's is the customer. So I would say that typically their expectation is that an ambulance be there as quickly as possible. If the emergency department is calling to say we need to move a patient to another facility in Albuquerque or anywhere else, typically their hope is and their expectation is that the ambulance will be there just as quickly as possible. The idea or the notion that a ambulance stationed at the hospital provides an unfair advantage seems silly to me, in that again, Rocky Mountain has been serving St. Vincent's for many years. I understand that their location, I know that their location is very close to Christus St. Vincent's, the matter of a difference of a couple of minutes. And the ultimate issue is not whether it's going to improve the response time by several minutes. Christus is expressed repeatedly that there are delays of hours for a Rocky Mountain ambulance to get there, and they need improved level of service and availability from ambulance companies. So it's a weird question to ask, but ultimately my answer is generally the customer, who is who you're serving, their expectation is that you'll send an ambulance just as quickly as possible.
Okay, in that answer, first you said, you used the example of transporting from an emergency room to another facility. Wouldn't that be an emergency transport?
No, not necessarily. Oh, I'm sorry. No, not necessarily.
So that wouldn't be the type of transport that typically, in this particular instance, Santa Fe Fire Department would do. Is that what you're saying?
Yes, sir, that's what I'm saying. In this example, right, the ER could be discharging a patient back to a nursing home who was there to be seen for dehydration or for a slip and fall or for any myriad of things. They need the bed in the emergency department to be opened back up so they can see another emergency patient. That patient needs to move to a home, back to their skilled nursing facility, to an inpatient bed in Albuquerque or any other myriad of locations. That is not typically what Santa Fe Fire would want to do.
Okay.
Sir, hearing examiner, is this
Yes,
a good time for a break? I need to reboot my computer.
Okay, well, that sounds like a good reason. It's been an hour. We can take a break. We're going to continue with Mr. Padilla's examination and Mr. Graham. It's only going to be 5 minutes, okay? My computer says 3:35. We'll be back at 3:40. Thank you, Mr. Bartel. Hi, I'm back. I'm sorry I was a couple minutes late. Let's see who we have here. Mr. Maurer, are you hiding back in that corner again? There you are. Okay, and we see the arm of Mr. Padilla's client, so that's always good. There's Mr. Borman, Ms. Dunn, Mr. Casper, Mr. Montoya, Mr. Archuleta, and then we have the telephone of the court reporter. Who are we missing here? Seems like we're missing somebody. Mr. Bartel, he's missing. So we'll wait a minute. He must have logged off instead of just turning off his screen. Was it Mr. Bartel that said he had to reboot his computer? Oh my, that's never a good thing. That takes longer than 5 minutes.
Yes, sir. He said he had to reboot his computer.
That
Okay.
is what he said.
Well, I hope he has a big boot. How would he know he has to reboot his computer? Unless it lights up and says reboot me or something. I mean, he was talking on his computer, I presume. Oh, well, we'll give him a couple minutes. This is our wonderful state of New Mexico where we all give each other a couple of minutes extra. Sounds like somebody's knocking. Maybe they're trying to get through.
Mr.
Oh, it
Hearing
doesn't.
Examiner, have you checked the waiting room, sir?
I have not. That's a good idea. You know what? Many apologies. You're absolutely right. Jeez. Thank you. Who said that? Is that Ms. Hoyman? Thank you. You're sweet. Were you the one knocking on my door? No. Okay. Somebody else. Mr. Bartel, can you hear me, Mr. Bartel?
Yeah, now.
Well, guess what? You have to thank Miss Hoyman because she just convinced me to release you from the waiting room. It's like, you know, a holding cell.
I was calling in.
Okay, but we can have visitors to the holding cell. Now you're in with all of us. I think we're all here, and since it's 3:46, and I really hope that we would be a little further along. But you know, it takes as long as it takes. That's been my saying when I do hearings. I give everybody their full opportunity to complete their cross-examination. That means you, Mr. Padilla. Are you ready to continue?
Yes, sir.
Okay, go right ahead. Back on the record, please. Go right ahead.
Mr. Graham, let me direct you to page 4 of your direct testimony, line 22. But before I get to that, let me ask you, did you participate in the preparation of your direct testimony?
Asked and answered.
You can, overruled, you can answer, sir.
Yes, I did.
Okay. Did you read it over to make sure it was what you wanted?
Yes, sir.
Okay. If you look at the question at line 22, it says, why do you think the service currently available from RMEMS, Santa Fe Fire Department, and Presbyterian is inadequate to serve Santa Fe County? Would that be correct?
That's what the question says. Yes, sir.
Okay. So the question, first of all, it excludes Superior. But in your answer, I do recognize that you make reference to Superior. And you were asked if you needed to correct anything on your statement before we started here. Was that just an error that Superior's left out of that, or was that intentional on your part?
No, I think it's probably just a lot of parties. It was probably unintentional. The caveat that I was also under the impression that while Superior has statewide authority, I do not believe them to have stationing authority in Santa Fe.
And what's your basis for that belief, sir?
I read their CON.
Could you, instead of using initials, tell us what you...
I read their certificate of necessity.
Okay, thank you, sir. Now, the question does ask why you think that Santa Fe Fire Department is inadequate. And I think, if I'm correct, that you start addressing the Santa Fe Fire Department at the bottom of page 5. But I'll let you look at that. And I guess I'm asking if your answer to that question is if you believe in any way whatsoever that the service provided by Santa Fe Fire Department is inadequate in Santa Fe County.
No, sir, I don't. The other part is I think you're taking it a little bit out of context, and that it's kind of like a going conversation. The question before had to do with interfacility transfer services, right? And so that's where we were talking about the whole text or the whole document, not just one specific question all by itself.
Well, I guess the reason I'm asking is because at the time that you did your testimony, you didn't have this settlement agreement that we talked about at some length this morning. So is your position with regard to Santa Fe County changed because there's now a settlement agreement, or is your position the same, and has it always been the same?
I believe my position, our position, has always been the same. Our intention is to operate in Santa Fe County specifically for interfacility ambulance services, not provide 911 services. And so the questions, again, we're asking towards what type of work were we going to do and who is currently doing the work.
And this information that you supply in response to the question about why you think the services currently are inadequate, is the information with regard to Rocky Mountain EMS, does that all of that come from your conversations with Krista St. Vincent, or did some of it come from other sources?
I'd say predominantly it came from Krista St. Vincent's, and yeah, I guess that would be my answer.
Okay, so on page 5, line 6, you say AMR had a conversation with Christus and Santa Fe. First, how did that conversation come about? Who initiated the conversation?
That's a good question. So again, remember, and clearly my memory for dates is not great. I'd have to go back and look at things. But originally, Rocky Mountain first was issued a cease and desist, or an immediate suspension well over a year ago, right? And you're probably very familiar with that event. That meant that they were going to have to stop operating, and it was the same sort of situation, stop operating immediately. There, of course, was lots of conversation, as there is this time, with them again being issued that stop operating order. And so naturally, Christus said, well, we're going to need additional help, or we're going to need help. I don't recall exactly how that came out. I think we probably reached out to them to say, oh no, I do remember now. I'm sorry. It's coming back to me very clearly. Ed Little, the owner of Rocky Mountain, reached out to us and said, hey, I'm being issued this suspension for a matter of whatever, 2 weeks, 3 weeks is what I think he thought it was going to be. Could you help support us at Christus St. Vincent's so that I can tell them, look, AMR is going to cover it, those sort of things. We engaged with Christus St. Vincent's at that point to see, hey, is there the opportunity? Are they interested in having us do that? And were they aware that Rocky Mountain was not to be operating in Santa Fe anymore? So that was the genesis of that.
So are you saying that it was AMR that brought it to the attention of Christus St. Vincent that Rocky Mountain's authority had at that point in time been suspended?
I don't know if we were the first ones to bring it to their attention, but we brought it to their attention at the request of Ed Little, saying, hey, we're not going to be able to operate in Santa Fe. Could you cover us in Santa Fe?
So your answer says AMR had a conversation with Christus. Are we talking about you've been talking about information that you got from Christus. Are we talking about information coming from a single conversation, a single meeting, or are the statements that you're making coming from multiple communications?
God, no, not a single, multiple communications, right? Again, this has been ongoing for a year. The services had not changed. In fact, I think Christus will testify that services, in fact, their perception of services, in fact, gotten worse. This has been an ongoing conversation multiple times. Again, this was in the context of reading and writing and answering questions. So a conversation is not just one single conversation.
Are the conversations always with the same person? And what I mean by that is there a point person that you contact, such as Lillian and Toya every time, or do you contact different people?
No, we've contacted different people.
And how do you determine who those people are?
Christus offered them. I didn't determine who they were. They were essentially said, "Hey, let's go through this person. Let's go through this person."
I guess I'm just trying to understand the context. Is it always you contacting Christus, or does sometimes Christus contact you to update you, let's say, with regard to the concerns?
I guess it goes both ways, like communication.
Okay. Was there only this one formal meeting that you talked about where you went to Santa Fe and met with multiple people, or were there more than one formal meeting?
Mr. Hearing Officer,
Yes.
I'm going to object again because this is direct examination. It is not cross-examination.
I was wondering if it was even friendly examination, because it's sometime helping your case with these
It does seem
responses.
to be helping my case, but it's improper.
So I would sustain. Please be a little bit more careful, Mr. Padilla. I would appreciate it. Thank you.
I'm just trying to get an idea, Mr. Graham, as to how all of this came about, all this information that you're conveying that supposedly came from people within the Presbyterian system. And you may have already answered as far as you're concerned what I'm looking for, but I'm trying to get an overall picture. So is there something I'm missing, or have you already answered the overall picture?
Same objection.
Sustained. Next question, please.
You say, page 5, line 7, that Christus specifically supported a request for temporary authority. Is that what we're here about today, is temporary authority?
No, we're not here today about temporary authority.
What's changed besides the fact that on Friday there was an order from the PRC?
Again, this application was and has been long coming. At the time we applied for temporary authority, I would welcome temporary authority still today, but ultimately we're asking for permanent authority. We had done a myriad of different kind of avenues to try to figure out how we could help with St. Vincent's, including asking for temporary authority to meet the need during the time that Rocky Mountain was out of service a year ago, and again now.
I may have misheard you, but did I hear you say at the time we applied for temporary authority?
We've applied once. Part of that application included an application for temporary authority.
Okay, and when you say part of that application, is that the application that's been admitted as APP1?
Most likely. I leave this up to the lawyers. I think there might be a temporary application or temporary authority application in conjunction with a permanent authority application. I'm not sure, but again, we've applied one single time for entry into Santa Fe. That included a request for temporary authority.
Okay. Page 5 again, sir.
you talk about, starting at line 22. As such, they regularly have, they being Christus St. Vincent, should be able to rely on and partner with an ambulance company who can meet their needs and help them compete in Santa Fe. You've already talked about that a little bit, but I want to focus on the partner aspect of it. Are you talking about an actual partnership, or you talking about, and I'm talking partnership in terms of the legal, a legal partnership, which means that you have an agreement with them as partners, or are you talking about something else?
I don't know what the legal definition of a partnership is, right? In no form or circumstances is AMR going to become a partner of Christus St. Vincent's in the legal sense. You guys would have to tell me what that legally means. I mean it in the sense, and this is my direct testimony, that they're a customer of ours and we are a customer of theirs. We meet with them regularly to understand what their needs are. They meet with us regularly to understand how we can improve the system. We provide ambulance transportation and they provide hospital and healthcare to the residents of Santa Fe. So a partnership in this scenario is one that takes the ambulance service to work with the hospital and understand what it is that they're dealing with and how the ambulance service can improve and really help that hospital improve its services to the public and to its community.
Okay. And you also say in that sentence to help them to compete in Santa Fe. What type of competition are you referring to?
For patients, right? For patients and bed availability. So a hospital generates revenue through having beds to put patients in and healthcare workers to meet those. And they, in ambulance services, believe it or not, but play an integral part of that in helping to move patients, to help the hospital run efficiently and effectively. And so and that's one sense in which the hospital can compete. If the hospital is kind of blocked up waiting for an ambulance service to move 1, 2, 3, 10 people and consistently shows that they are having delays in moving people, they end up in turn losing bed availability at an accepting hospital, not being able to take new patients, not being able to operate efficiently, having backups in the emergency department. Those are all things that the hospital has to take into consideration every single day. And ultimately, they've now clearly expressed they need help improving.
So we're not talking about competing with the Presbyterian Hospital in Santa Fe. Would that be correct, or is that included?
No, I think that's in part included. I don't imagine Presbyterian has these same ambulance backup and delays, right? Or they'd be saying to their hospital or to their ambulance partner, Albuquerque Ambulance, you need to improve. And Albuquerque Ambulance would say, we understand, we hear you. If nothing else, they would say, here's the data that we have that shows this is what we're doing. These are what our response times look like for you. This is what our level of service provides for you. If you need additional levels of care, if you need additional pieces of equipment, if you need additional whatever, they'll work in conjunction with one another. I have no doubt that Presbyterian has that with Albuquerque Ambulance. So in that form or fashion, absolutely, it is a compete with Presbyterian. They need to have the same level of ambulance availability, same level of competency, same layers of confidence that the ambulance provider that they are working with is going to provide safe, effective, and adequate treatment and availability of ambulances. And that helps them compete with Presbyterian.
Wasn't the situation with Presbyterian and Albuquerque Ambulance different because Presbyterian Healthcare actually owns Albuquerque Ambulance?
Mr. Hearing Officer, again, we're starting to wander off the mark.
Overruled. I'd like to hear the answer to the question. Thank you. Answer, please.
Mr. Padilla, I need you to, I was going to say, I don't understand your question.
Well, you're talking about competing, and in your answer, you use the example of Presbyterian saying to Albuquerque Ambulance that, you need to step it up or whatever. And my question is, isn't the situation between the Presbyterian Hospital in Santa Fe and Albuquerque Ambulance Service a different circumstance than the circumstance AMR would have with Christus St. Vincent, because Presbyterian Healthcare Services actually owns Albuquerque Ambulance Service.
Okay, the objection is sustained. He's already answered all that stuff, Mr. Padilla. He's explained the corporate structure, how he fits into the corporate structure. At no time did he say corporate structure was any part of Christus St. Vincent. In fact, he said they're not going to partner with Christus St. Vincent. So I think he's given you the answer, and it's quite clear to me. I think it's an understandable answer. So to prevent us from re-asking the same questions, I'm going to sustain that objection and sustain any other objections for questions that have already been asked and answered.
On page 7, line 8, or page 7 of your testimony, starting at line 4 and going through 7, it talks about dispatching of ambulance services in Santa Fe County. And you say they would be dispatched via radio and phone, and you'd use AMR's dispatch center, correct?
That's correct.
So would that be the case, even though AMR might be stationing for some period of time at the hospital in Santa Fe, Christus St. Vincent Hospital?
Yeah, of course, we would use radios in our dispatch center, right? And I think that's one of the other real advantages that every hospital should be afforded, and quite honestly, all ambulance services, right? So a computer-aided dispatch center or a CAD and dispatchers are really an integral part of providing ambulance services. The CADs, dispatch centers, dispatchers all help with tracking the same sort of things, the data points that we're all talking about here apparently are a lack, in that there are documented times that an ambulance was requested, time the ambulance arrived at the scene, time the ambulance transported the patient, time the ambulance arrived at the receiving facility, time the ambulance was available back in its area. All of those sort of things are managed and measured through a dispatch center and a communication center. So yeah, of course, we would bring to the table our CAD and dispatch center. Part of that includes online ordering capacity for the hospital to be able to get online and order an ambulance. Part of it helps reduce unnecessary phone calls or additional phone calls. But what we really need to move away from, and what we've heard from Christus St. Vincent's as well, is that we need to improve from just the hospital calling a supervisor on his cell phone at 10 o'clock at night, and maybe that person is on a call, maybe that person is not on a call, transporting a patient. It needs to be to a communication center with dedicated dispatchers who can answer those questions and help facilitate that request.
So even if AMR is stationed at the hospital in Christus St. Vincent, somebody from the hospital would make a call to AMR's dispatch, and then AMR would dispatch the unit that's already there. Is that what you're saying?
Yes, absolutely, Mr. Padilla. I guess the flip of that is your assumption is that an ER nurse would run down to the door and knock and say, hey, we got a trip to Albuquerque. That's not how we handle things. No, calls go through our dispatch center. They're logged. They're tracked for times. Patient information is entered. Physician certification statements are all gathered. And then the ambulance is dispatched.
Okay. Page 7. Line 8 through 10. The question is, how would AMR staff its ambulances in Santa Fe County? The answer is AMR would staff ambulances with 2 licensed individuals, one of which will be licensed as a paramedic at minimum. What does that mean, 2 licensed individuals?
2 individuals with New Mexico EMT licenses.
Okay, so at all times you would, you say one of which will be licensed as a paramedic. So just to be clear, are you saying each ambulance is going to be staffed with a paramedic and an EMT, or is it at least 2 EMTs?
With one paramedic and at least an EMT.
Okay, so does AMR not use people who are simply designated as drivers?
No, we typically do not. We see it as, well, I'll just say no, we typically do not. We feel like it's advantageous for us to have 2 EMTs on all of the ambulances.
Okay. But does it stand to reason that employing 2 EMTs would be more expensive than employing, or an EMT and a paramedic would be more expensive than employing a driver and a paramedic?
I feel like it probably does stand to reason that it's a little bit more expensive to staff with 2 EMTs rather than 1 EMT and 1 driver, but the advantages, I think, outweigh the very minimal cost difference.
When you say very minimal cost, what are we talking about? Are we talking about $2 an hour, $20 an hour? What are you talking about?
No, I think closer to the $2 an hour range.
Okay, so going down to line 16, you talk about the annual projected revenue for Santa Fe County is 800,000. You've already testified that that's the entire projected revenue, correct?
Correct.
And then you testified, I'm sorry, go ahead.
Said gross revenue.
Gross
What's the
revenue.
gross revenue.
Okay. And then you've already testified that the 44% would apply to that gross revenue, so you would end up with a net of 352,000. Is that correct?
Again, I didn't do the math on the calculation, but I have no reason to doubt you.
Okay. So then finally, you said that you're estimating approximately 2,000 runs, correct?
Correct.
Okay, so I did the math, and I'm not telling you I'm an expert mathematician, but by the math that I did, if you divide 352,000 by 2,000 runs, that ends up with a net per run of $176. Is that reasonable to operate an ambulance service with the type of quick, efficient, full service that you're talking about?
You know, I've not done the math. With the 177, and when you consider Medicaid and Medicare reimbursement inside of the city, it sounds like it potentially could be about right. I feel like our net collection overall would be higher than 177, but I've not done the math. Again, we have finance teams who do this sort of thing, and clearly I'm involved with it. But again, I haven't done the math on your division there.
Okay, well, what I'm concerned with is you've said you want to improve service, and Krista St. Vincent, I think, has been made clear here that Krista St. Vincent wants improved service. And in your experience, and you have quite a bit of experience in this area, based upon your experience and knowledge, is $176 per run, if I did my math correctly, sufficient to provide that improved service in response time, in the nature of staff that you're providing, all of those factors that you've already talked about?
I would separate improved services from revenue, right? And again, we'd have to talk with really the finance teams on the revenue numbers. The improved service is really an operational issue, and that comes in that again, it's dedicated ambulances, it's 2 EMTs, it's improved equipment, it's efficiencies in operations through CAD systems, through dispatch centers, those sort of things.
Okay. You talked a little bit with Mr. Bartell about the RFP. Was the RFP the result of this initial meeting that you had back with Krista St. Vincent about a year ago, or is that something that developed over time?
The RFP discussions is something that developed over time. Again, when we first engaged with Rocky Mountain, with Christus, it was because Rocky Mountain had been suspended. Christus needed help. We applied for temporary authority and ultimately for authority. And then I don't know, maybe 6-8 months later, after Rocky Mountain had been returned back into service, Christus St. Vincent's went ahead and released the RFP because they still felt like they needed additional support and improved services.
So was the RFP the idea of Christus St. Vincent, or was it suggested by AMR?
It was Christus St. Vincent's idea. Continues to be. I'm not going to change my answer depending on who asks me that.
Okay. Now, at one point when you were talking to Mr. Bartel, you were talking about providing, and I wrote this down, interfacility dedicated ambulance service. What do you mean when you testified that the intent is to provide dedicated ambulance service? What do you mean?
Ambulance service is dedicated to doing in-facility scheduled and unscheduled trips.
So it's not dedicated in the sense that the ambulances that you would have in Santa Fe are dedicated solely for the use of Christus St. Vincent?
No, sir.
Okay. You said Christus St. Vincent announced the RFP by sending an email, correct?
That's how I got the notification. Yes, sir.
Okay. Was that notification, was the email specific to you, or was the email to you and the 3 other people who the RFP was sent to?
I don't recall seeing any other names on there, but I think it were blind copied, so maybe they were on there. I don't know.
Do you know who the other 3 are?
I've testified that I do not. I can speculate if you like me to.
No, I don't want you to speculate. I was just interested in whether or not you recollect if the email said something, and by asking the question that way, maybe it would jog your memory, but obviously you don't remember, correct? You don't know, right?
Getting the email. I don't know if I was blind copied and somebody else was on that email that I didn't see.
Okay. You said that AMR assumed that 1,500, 1,700, these 2,000 transports would come from Rocky Mountain. Was that just an educated guess, or did somebody give you that specific number?
I said that the 1,500 to 1,700 would come from Christus St. Vincent's.
Okay.
And that's an educated guess.
Okay. You also said that Christus St. Vincent's was primarily using Rocky Mountain, correct?
That's correct.
So would it be fair to conclude that the majority, or perhaps all of those 1,500 to 1,700 would come from Rocky Mountain?
Well, again, I think that miscategorizes it, that their work that Rocky Mountain had been doing up until Friday, but the calls originate from Christus St. Vincent's. Christus St. Vincent's is the customer. Rocky Mountain is the operator who was trying to serve that customer. So those calls originate from Christus St. Vincent's. They don't belong, if you will, to Rocky Mountain.
So would it be fair to conclude then that before last Friday, before the suspension that was issued last Friday, that AMR anticipated taking over the business that Rocky Mountain had with Christus St. Vincent?
Yes, sir.
Did you have anything to do with obtaining the original affidavit of Lily Montoya that accompanied the application of AMR?
Well, sure. I met with her. I talked with her. And her team. We talked about part of the application requires that we have an affidavit from an entity or somebody showing that there's demonstration of the need. So that was part of our discussion. Yeah, naturally.
Okay, but you didn't assist in drafting the affidavit, did you?
Assist in what?
Drafting of the affidavit?
No,
Did
sir.
you write it?
I did not.
I'm just looking as quickly as I can, Mr. Hearing Examiner, to see if I have any other follow-up questions to the previous cross-examinations.
Thank you, Mr. Padilla. I completely understand. So do what you have to do. While you're doing that, I'll announce that it's 4:20 p.m. I don't believe we're going to get to any more witnesses after Mr. Graham. Something for you guys to start thinking about until we finish with him, what we're going to do after that. We have 2 scheduled for tomorrow morning. And after that, we'll take them in order. We'll just go as we go.
Mr. Hearing Examiner, I recently received a text message from our witnesses at Christus. They have thankfully just received their first shipment of COVID vaccines, and they want to know if they can delay their testimony to 10:15 because of COVID-related obligations at 9 o'clock.
Why don't we start one of them at 9 o'clock and we'll get to the other one when we get to the other one, which is probably going to be after 10:15. Is that, I mean, we're not going to need both of them at the same time at 9 o'clock. You know, I don't know how to say this, but
if either one of them can get loose.
this is not like we're all just meeting around some coffee table somewhere. This is a hearing. We have a lot of preparation that's gone into this, including yours. We have burning a lot of lawyer time, as I call it, billing a lot of hours for clients. This is a state proceeding, even though it's on Zoom and it seems pretty informal. And I do like to keep it as informal as possible to keep the tension down. But, you know, we've given these guys a couple breaks already, so to speak. And I would ask that one of them be here tomorrow morning around 9 o'clock. And then we'll do the other one after that. Yes, sir. Are you ready to continue, Mr. Padilla?
I am, sir.
Mr. Murray, do you mind if he continues while you're typing into your computer there?
No, sir.
Okay, go ahead, Mr. Padilla. Go forward.
In cross-examination, you say that Christus St. Vincent has shown an ongoing need for ambulance service. When you say ongoing need, that was even before this situation with the suspension of Rocky Mountain, correct?
That's correct, Mr. Padilla. We're in this position right now because Christus St. Vincent's has expressed repeatedly over and over again, and they demonstrate that they need additional ambulance support. We're in this position today because, quite frankly, your client, Rocky Mountain Ambulance, has done a terrible job of providing adequate customer service and ambulance service to them. We can keep on talking about this, or we can finally agree to just stop kind of beating around the bush. It makes everybody's kind of on the same page, I hope, with this, and including the CEO of the hospital trying to testify. And again, with all due respect to everybody, we're also in a pandemic and everybody is busy and everybody's got a lot to do. And ambulance services should not be this complicated for a hospital system to try to get. So yes, to answer your question, they have expressed over and over and over that they need additional ambulance support, that they need better qualified individuals. They need employees who will show up and not refuse to wear a mask during a pandemic. They need ambulance services who will report to them when sentinel events happen. They need ambulance services that will share with them data to help them understand what their patient flows look like. They need so much that during our first meeting with them, they offered to let us stay at their hospital. These are all indicative of big problems in the area. And we can keep on talking about what did they show you? What did they give you? How come you guys get to station at their location? Or we can just say, yes, we're here because specifically Rocky Mountain Ambulance has done a terrible job of providing good customer service.
Mr. Hearing Examiner, I understand the frustration of the witness at my questioning, but would you instruct the witness not to instruct or scold the attorneys in this particular matter because he happens to be frustrated?
Well, thank you, Mr. Padilla. I understand. And I do understand his frustration. I don't know that I'm going to instruct him not to scold him lawyers because I don't think he effectively accomplished that. And I think you're quite a tough character yourself. Mr. Graham, the thing is, we're dealing with state regulation here. I'm dealing with state regulation. And we have concepts within the legal field concerning due process, which has given everybody their right to speak and have their case heard. And that's exactly what we're doing. We're giving you the right to have your case heard, essentially. And unfortunately, they say there's a no-sum game type of situation, or there's only one pie that gets cut up. In these cases, there is a bit of a pie. Sometimes the pie gets bigger, sometimes it gets smaller, thicker, thinner. But Mr. Padilla asked questions on behalf of his own client. And I have no problem with him doing that. And I'm sure you would understand if Miss Majori wanted to ask questions on behalf of you, that we allow her to do so. And I certainly would, just as I do for Mr. Borman, just as I do for Mr. Maurer and Mr. Bartel. Everybody gets their shot at it, and you're getting your shot at it. We're all here because of you. We're here because you filed the application. If you have frustration with state government being involved with the business of providing ambulance service to hospitals or anybody, I understand that frustration also. But we're going to live within the realm of the world we all live in right here, and that's regulation by our state government pursuant to the laws of our legislature on behalf of our citizens to regulate businesses, including ambulance services like you are. I can't change that with this hearing. So that's the unchangeable part. Anyhow, I'm making this hearing take even longer, so I'm going to be quiet there. Mr. Padilla, are you finished your examination of this witness?
I just have a couple more questions, sir.
I was afraid of that, so go ahead, ask him, please.
This ongoing need that you made reference to in previous cross-examination, are you talking about the ongoing need that exists because of what you have stated is the failure of Rocky Mountain to adequately provide service? Or are you talking about ongoing need from new additional patients?
Ask and answer.
Yeah, ongoing sounds to me like something different than additional sustained. Please ask another question or rephrase it so that it makes more sense, please.
I'm trying to understand when you say ongoing need, and because we have two different circumstances now. Before Friday, we had a circumstance where Rocky Mountain was providing a service. And as we sit here today, they're not providing a service.
So are we talking about ongoing need?
Well, he hasn't filed any applications I know of since Friday. So, you know, obviously this is an old application, Mr. Padilla. Friday just happened to happen on Friday. That sounded a little like lawyer talk. But, you know, we didn't know that that decision was going to be on Friday. We didn't know there'd be a hearing on Friday. We didn't know that matter would get to the commission on Friday. I certainly didn't know. I don't think you knew. But there was, you know, it did. So I don't know how Mr. Graham could have possibly known more than you know, or more than I know, or any of us knew.
I'm just trying to get clear, Mr. Hearing Examiner, whether this need is an ongoing need only of Krista St. Vincent, number one, and number two, ongoing need due to the fact that Rocky Mountain wasn't providing adequate service.
Okay,
That's-
Mr. Graham, did you understand that question, and can you answer those two questions?
I believe so, sir.
Please do.
Thank you. The answer is yes, essentially to both. We believe that there is an ongoing need. There was an ongoing need prior to Rocky Mountain suspension. That ongoing need has been further exacerbated by the suspension of Rocky Mountain. So again, to answer your question in short, yes, we believe that it is both.
Thank you very much, sir. That's all I have, sir.
Thank you, Mr. Padilla. Okay, we have Mr. Borman left. Correct? You have any questions, Mr. Borman?
I do not have any questions for Mr. Graham.
You're a saint. Thank you, Mr.
Tell
Borman.
that to my wife.
We've had this conversation before, I think. Okay, now we could move into redirect. You know, I think redirect's got to be strictly within the cross-examination, and I would like it to serve one purpose, to clarify something which could be misinterpreted. I don't really think it's a time for further advocacy on this type of an administrative hearing. So, have any of you council felt the need to have redirect examination? Ms. Maggiore?
I may just have like one or two questions. It's not going to be much.
Okay. Anybody else feel the need to do any type of redirect examination of this witness?
With all due respect, Mr. Hearing Officer, I think I would be the only one because I'm the only one who did
Offer
direct.
direct testimony.
Well,
I get that.
If it would be permissible, I do have a couple of questions that are very focused.
What I meant was, okay. All right, Ms. Maggiore, why don't you go forward with your redirect question, and then we'll go to Mr. Maurer. Thank you.
Yeah, and I would object to recross because that's not contemplated by the rules. Mr. Graham, you were asked whether one of the reasons that the term ambulance services is kept general. Let me rephrase that. You were asked about the generality of the term ambulance services and why the application does not specifically apply for interfacility services. Did you recall that?
I do, yes.
If mutual aid were to be requested in the event of a multiple casualty incident or some other unforeseen circumstance, would AMR want to have the flexibility to assist in that manner if requested by Santa Fe Fire?
Yes, we would.
Can you explain that in a way that our colleagues can understand why that's important?
Sure. If in the event that there's a Greyhound bus versus semi, which we all experienced last year out in McKinley County, we know it is a reality, anywhere near Santa Fe, we would like to be able to respond via lights and sirens to that request at the request of the responding agency, right? So I think it would be short-sighted to limit us to say, no, you absolutely cannot do that in the event that somebody asks you to go respond to a call like that.
All right, thank you. Moving into a completely different area, you were asked whether you had any data showing specific dates and times where Superior or Rocky Mountain were asked to take a call and were either unavailable or delayed. Do you recall that?
Yes.
Does AMR track that sort of thing through its CAD system?
Yes, we do. That's a normal part of our ability to understand our organizations, our operations, and the demand for services so that we can facilitate adequate and appropriate staffing levels. So we absolutely do track those. When a hospital calls us, we know what time they called, what time they were hoping for pickup, what time they want to schedule a trip for, and we can provide that data. It's a part of it. I think in that answer, I talked about the ability to measure and manage, right? So if you can't measure something, you can't manage something appropriately. And what I seem to me to be apparent is that the organizations in Albuquerque, and I'll rephrase that to say Rocky Mountain and Superior, neither seem to be measuring that metrics. And it's convenient to be able to say, no, it doesn't exist. Oh, it exists. You're just not measuring it. And if you can't measure it, how can you expect to improve from that?
Right, and you were asked on cross-examination if you could provide that information. Did AMR request that information from Rocky and Superior in discovery?
We did, yes.
And what did we get in return?
We got nothing in return.
All right, so how could you be expected to speak to that data if it doesn't exist?
I couldn't. The data, it's inherently incumbent on Rocky Mountain and Superior, predominantly in this example, to provide that data for us.
Why is it important for an
Mr. Hearing
ambulance?
Officer, and I hate to interrupt, I'm going to object to that question in the answer provided because it misstates the responses that were provided to discovery.
Okay, well, I'm going to allow you to clear it up when you examine this witness right after Ms. Majori. Okay, so it's overruled for now.
Why
Go
is it important for an ambulance service providing interfacility transport to create and keep and maintain that data?
It's important predominantly so that the ambulance service can understand its typical demand. So we understand that it gets busier on a Wednesday, or it gets busier on a Friday at 3 o'clock, or it gets busy and there are going to be 4 or 5 typical requests on a Monday morning at 8 a.m. All of those sort of things are nuances that exist differently in different hospitals in different parts of the state and really in different parts of the country. But without that data, all you're really doing is providing a 24/7 service that may or may not be meeting the needs of that particular customer. And in this case, Christa St. Vincent's, and they are not meeting the needs of that particular customer. But without collecting that data, having that data, and understanding that data, you simply can't improve or understand where you need to add additional ambulances, what's causing potentially even the ambulance services delays, right? Is it an issue of the ambulances are getting backed up at another hospital? Is it an issue of they're getting stuck in traffic patterns on a construction project somewhere? All of those things speak to and are inherently important data points for any ambulance operator to be able to effectively manage their system.
And if you don't track that data, how would a service know if it was meeting the needs of its territory?
They wouldn't, right? So typically what we do is meet with a hospital to say, let's sit down together, figure out what works for you all with regard to response times, and then enter into an agreement that spells that out. So as an example, we would say, okay, so when you request us for unscheduled, and it comes from the emergency department or the ICU or the obstetric unit, we'll get an ambulance. We agree that we'll get an ambulance to you within 30 minutes. Versus when you call us for an immediate pickup, it's unscheduled, and the patient is up on the floor of the hospital and needs to go somewhere else, we'll agree that that will be a 45-minute or an hour pickup time. But those are all the things that speak to the partnerships that ambulance services should be establishing with their hospitals in their area. Without that, you essentially are just an on-call commodity, if you will, and that's not an appropriate way to operate an ambulance service. It's definitely not an efficient way to operate an ambulance service.
All right, those are the questions that I have. Thank you, sir.
Thank you very much, and thank you for keeping them short. And as for me calling it redirect or rebuttal or direct testimony or cross-examination, this is an administrative hearing, and for structure, I use the structure we typically use in a district court type trial proceeding. However, the reality is, in an administrative hearing, it's my objective to get as much meaningful information as possible. Unfortunately, that's tempered for me because I can't advocate for any of you, and I'm very careful not to do so. So I don't get involved in your presentation of your cases unless it's a very important issue that has to, where I need the facts. So I sit back and let you guys do the work. And but whether we call it redirect, which was the wrong term for it, or we call it rebuttal, which is perhaps more accurate, or call it re-cross-examination, it doesn't matter. If Mr. Mauer's got some sort of new, more clear information, which is going to help me do the case, I want to hear about it. So that's the way I see it. Mr. Mauer, did you have some kind of question to clear something up?
Well, Mr. Hearing Examiner, all I objected to was, I think that the testimony offered by the witness didn't clearly state the objections filed by Superior with regard to providing that information, and that the objections were that it was proprietary in nature, and to collect it and provide it to them would be overburdensome on the staff, not that Superior didn't have it.
Okay, Mr. Graham, is that in fact the response you received, if you know?
I'd have to go back and read it, but ultimately, yeah, I think so.
All right, thank you, Mr. Graham.
Thank you.
And he's under oath. Remember that, Mr. Mauer?
Yes,
So
sir.
when I hear it from him, it's different than when I hear it from you. All right, I just had one question I want to clarify. Mr. Graham, you know, I'm looking at your direct testimony as well. It's in question and answer format. My question is, did you prepare both the question and the answer, or did you prepare just the answer? And if so, who prepared the questions?
The questions were prepared by our attorney, and I answered the answers, obviously.
All right, that was my only question. Because I've just asked another question. I'm going to allow Mr. Bartel and anybody else that has a question in the scope of the question I just asked to follow that up. Mr. Bartel, you have something within the scope of that single question?
Mr. Hearing Examiner, I had asked for leave to ask him questions before you asked that question. I think you mistook me for Mr. Mauer.
You know what? I think you're absolutely right. I think I did. You know, this is the nature of being on Zoom. If we were in the same room, I would have saw your right hand twitch, or I would have seen your head nod.
Well,
we don't have any of that.
So that would have helped.
Not to mention the muting situation. So I hope that it's to clarify something which wasn't clear during the direct or the cross, but go ahead, Mr. Bartel. What's your question?
Yes. Mr. Graham, I just wanted to ask you if you had ever become aware of the following scope of the authority that was granted to Albuquerque Ambulance Service to station in Santa Fe County. And it reads as follows. Interfacility scheduled transport service over irregular routes between points and places in Rio Arriba and Santa Fe counties, originating in Rio Arriba and Santa Fe counties on the one hand, and destination points and places in the state of New Mexico on the other, with equipment stationed in Santa Fe County only. Were you aware that that is what resulted from Albuquerque Ambulance's application for stationing authority in Santa Fe County?
I think I would say I'm aware of that, except for the part that you read about the interfacility, and I'd actually ask you to reread it. I found a lot of interest in that. Interfacility, that part is new to me.
So the sentence reads, quote, interfacility scheduled transport service over irregular routes between points and places in Rio Arriba and Santa Fe counties and originating in Rio Arriba and Santa Fe counties on the one hand, and destination points and places in the state of New Mexico on the other, with equipment stationed in Santa Fe County only.
Thank you for rereading that. No, particularly the part about scheduled interfacility is new to me. I did not know that if I'm understanding you, their certificate limits them to providing scheduled interfacility ambulance services in Santa Fe.
Okay.
Thank you, Mr. Bartel. Anything else?
Nope, that's all I wanted to clarify.
All right, wonderful. Well, guys, it's 4:44 and our Miss Hoyman likes to go home or whatever she does if she's already home. I planned this to end at 5, even though I scheduled it to 7 in case you guys all twisted both of my arms and insisted that we continue on to 7. Does anybody want to start a new examination of another witness? I'm dissuading you, but if you have a strong desire, tell me why.
Not on my behalf.
There's a no. Ms. Maggiore, are you finished? Are you fine with stopping for the day?
Yes, sir, I am.
And Mr. Padilla,
I'm going to try to get my Christus witnesses in as early as possible tomorrow so that we can just go straight through our case, if that's acceptable to you.
it's acceptable if we can have just one of them ready to go and then maybe notify the other and we take a break and try to get the other one available. If it's, whatever works, but somebody should be here. We've made an accommodation to switch them from one day to another. And, we're all fair, but, I don't know what the call would be tomorrow morning at 10:15. So I'd rather just go with what we've got right now. Mr. Padilla, you don't want to start examination, do you?
No, sir. I do think I do need to advise you, however, that my witness has told me that he has a meeting tomorrow that he can't get out of. He's, as you're aware, he's not employed by Rocky Mountain EMS. He has a different job. He's got a meeting from 11 to 2 that he thinks he might be able to cut short, but hopefully we'd be able to work around that.
Let's see how it goes. We may not even get that far because we've got the two Christus witnesses. Then we got Archuleta and Casper, and then he would typically be next. That could be late afternoon, realistically. Okay.
Well, hopefully, I just wanted to let you know.
All right. Thank you, sir. And Mr. Borman, you concur that we're not going to go forward any further?
I am fine with that.
And Mr. Bartel, good with you too?
Yes, that's fine.
Okay. This is going to, we're going to continue this hearing tomorrow morning at 9 a.m. Same place, same channel, I believe. I scheduled this for actually 3 days on Zoom, so we should have no problem getting on. I think you clicked on the same link. Does anybody have any questions or any comments before we continue the hearing until tomorrow? Nothing. Okay, most excellent. Thank you for everybody who appeared and didn't get a chance to talk. I apologize, we just didn't get to it. See you all tomorrow morning, 9 a.m. Adjourned for the day.
All righty. Thank you.
Thank you.